May I please look? Lordship have passed one bail order on first of this month. That your Lordship have passed some bail order on first of this month. There's some modification needs to be done, Lordship.
What?
Lordship on
Tomorrow?
petition. But today,
What modification?
Lordship, there the point number 12, Lordship. We have filed IA regarding this interrogatory application.
Point number 12.
Today we have filed. It may be taken up.
What you have filed?
IA, Lordship.
IA.
Yes.
Today?
Yes. It
This is
may be
last
taken.
You are also hearing?
Yes.
I is for just for possibly one verification. There are 2-3 conditions.
Okay.
It appears some verification necessary.
Okay.
I may be kind of taken up and listed tomorrow.
Okay.
May it please the Lordship. I beg to mention item number 6, Lordship. Lordship, I may be allowed to withdraw this petition, Lordship.
Maybe.
AB, Lordship.
Your Lordship, this is a MSc appeal case.
Just a minute. You Mr.
PP Fukan, Lordship.
Counsel for the petitioner wants to withdraw this petition. So this petition is dismissed on being withdrawn. Okay.
Lordship, obliged, Lordship.
Your Lordship, it is a MSc appeal case. It may be listed on this 10th.
Okay.
Your Lordship may have mentioned for anticipatory bail for today. It may be listed at the end of the matter. AB for today.
AB.
Yes.
Okay.
6 in number, arising out of same FIR. Public.
Lordship, this is a joint petition. Here, the petitioner number 1 and petitioner number 2 are husband and wife, whereas petitioner number 3 is the friend of petitioner number 1 and 2. Your Lordship, here the petitioner number 1 has lodged an FIR against the petitioner number 2 and 3 on dated 24/2/2024, alleging that petition number 1 and petition number 2 and 3 has assaulted her. So FIR is at page number 21. Your Lordship may kindly come to page number 20. Yes, married. It is to inform your good office that today on dated so and so, my husband so and so, son of so and so, resident of so and so, have assaulted me physically on my face and head at my rental residence at around 9:30 a.m. at Bogdo.
Okay. Thereof the case was registered.
Case was registered under section 323, 498A and 34. And it's still under investigation.
Non-compoundable.
Non-compoundable.
All.
On Lordship, 323 and 498A non-compatible. Punishment is 1 year and 3 years.
Okay. So then,
Lordship, and as it is a matrimonial dispute between the parties, they have already settled the dispute between themselves, and they have executed an settlement deed on 3rd March 2024. It's in page number 23. Lordship.
what uncompoundable? Have you informed this to the police? When this agreement was entered? When the case was settled? Oh, yeah. In this case. Okay. Yes.
Lordship, as per the FIR lordship, 498A cannot be attracted lordship.
Yes, sir. That is
Because
the-
498 is a cruelty against the victim by the relatives lordship. Where real lordship, as per the FIR lordship, the husband lordship and this girl, they attacked her lordship. The trespassing his whole house lordship, her house lordship. Then its sections also not fully attracted
That,
as per
that
the.
cannot be determined here, what section can be. As it has been already been registered, so lordship, on that basis only we can.
And lordship, this FIR is for the quashing will be FIR
What is
lordship.
the status of the
It's
investigation?
still in investigation stage.
Now, how do we interpret them?
Yes, sir.
We can call for CD at this stage.
After this, sorry, scan copy of the case study may be called for and not.
God, Mr.
Yes.
Learned counsel for the petitioner. Also heard Ms. El Hage. Learned additional PP. No, additional PP,
Yes, lordship, just nothing.
government PP, staff. Para. This is an application under section 482 of the Code of Criminal Procedure 1973 for quashing and setting aside of the ALO women PS case number 02/2024 dated 24/2/2024, registered under section 498A 323/34 IPC. So both the accused and the petitioner, joint petition. Okay. Since Ms. El Hage ran an additional PP accepted notice on behalf of the state, no formal notice need be issued to the respondent. You have received the copy,
Lordship, yes, lordship, I have. Lordship.
extra copy not
I
required.
have not
Okay.
required, lordship.
Just a minute. Call for the scan copy of the
Case study.
CD. The ADPP also produce the status of the case.
Lordship,
Okay. List this matter of after. Which PS case?
Hello, please.
hello,
Okay.
yes, lordship, then-
After 4 weeks.
Fixed date pending on 24th.
Okay, list this matter on 24. Let's pray for by the parties. List this matter on 24.
Public lordship.
Bibliography.
My lordship, this is also a joint petition lordship for passing of FIR lordships
Okay.
filed by the alleged accused persons, petitioner number 1, complainant as a petitioner number 2, and victim as a petitioner number 2 lordships. This is for passing of FIR number 9 of 2020, dated 19.
The person was arrested.
Accused was arrested and released lordship. This is a 2022 case lordship.
Okay.
And now the settlement, they settled their once for all lordship.
Then the case must have, then case has already been charge sheeted.
Not substituted lordship.
2000, which case, case of which year you said?
2022 lordships. 2022.
Investigation. of-
323 lordship. Voluntary causing hurt to deter public servant from his duty.
Did you try before the trial court?
Lordship, this is, yes, lordship, magistrate lordship, but this is a non-compoundable also lordship. And
No. What I'm asking is whether, have you tried? No. Charge sheet not yet filed.
yes, lordship. Charge is not yet filed lordship.
Have you informed this, when this deed of settlement?
Lordship,
And
deed of
here-
settlement is recently lordship entered 24 March of 2024 lordship. And except 26 lordship. Lordship, at this, Lordship, settlements agreements annexure 6, Lordship, page number 35, Lordship. Start from page number 35, Lordship.
Yes, please.
Here also Lordship case,
2032 case.
Lordship. But Lordship, here they have annexed the Lordship statement.
Investigation not yet completed.
Lordship, here Lordship, they have annexed that statement of accused also Lordship, 161 also Lordship. Lordship, may I produce the status of the case Lordship, investigation Lordship. Same Lordship, status report and the update, scan copy of the case that may be posted.
Pardon, Mr.
Lordship, if Lordship charge is not filed, Lordship, no coercive actions against the Lordship petitioner, Lordship.
You said you have already been, you were arrested earlier,
Lordship released, Lordship.
Hmm?
Released, Lordship.
are arrested and released
Yes,
also.
Lordship, yes, Lordship.
What coercive action they will take?
Lordship, if during this pendency of this case, Lordship, charges is filed, Lordship, my case will be infractions, Lordship. In case, Lordship, if charges is filed during the pendency of this case, Lordship, my case will be infractions.
Okay, pardon, Mr. Gamkenbaum. Land counsel for the petitioner. I've also heard Ms. Lakshmi, land additional BP. So, this is a joint petition filed by the there are two accused and one informant.
One accused, Lordship.
One accused.
Yes, Lordship. Petition number 2. Lordship.
Okay. Accused and the
Petition number 1, Lordship.
under section 482 of the Code of Criminal Procedure. For quashing and setting aside of the ROPS case number 09/2022, dated 19/2/2022, registered under section 341, 354, 323, 332 IPC, read with section 4 of Arunachal Pradesh Protection of Medical Service Institution Act 2019. Start. Issue notice returnable by 4 weeks. Since Ms. L. Hage has already L. Hage appeared and received notice on behalf of the respondent, no formal notice need be issued. Extra copy not required.
Not good.
Okay. Also, the scanned copy of the case diary, as well as the status
That's
of the investigation of the above PS case. Okay, just a minute. Call for LCR, stop. Miss L. Hage shall also produce a status report of the above PS case on the next day. List is after 4 weeks.
like
List is after 4 weeks.
No coercive action, Lordship.
They will not take, they did not act after you have been arrested, released, and then you seek investigation not yet completed. What coercive action they will take?
During the pendency of this, Lordship.
During the pendency.
Fine, Lordship.
Okay. During the pendency of this petition, no coercive action shall be initiated against accused. Okay.
like
Highly advised.
May I please, your lordship?
Yeah.
Item number 3, 4, I'm appearing.
Hmm?
I'm appearing item number 4.
4.
Yes.
Okay. And 3, please.
Seems the council in item number 3 is not present today.
Yes.
Since these two matters are connected,
Hmm.
it would be better if both are heard.
In 4, you are for the petitioner.
Yes.
Okay. Who is for the respondent?
For the state respondent, Doctor.
State. And
Wakalanama has been filed on behalf of the private respondent.
4.
For 3, I'm representing 3, Lordship.
For the state. And then private respondent. What about the private respondent?
Coast list shows that Mr. Perme is appearing, has filed Wakalanama. He did not appear last time.
Okay. What do we do?
Lordship, another date may be fixed, Lordship.
Hmm?
Another date may be fixed.
Okay.
Because both will be needed.
Is prayed for by Ms. Nikita Dangan, counsel for the petitioners. Please this matter after.
Lordship, a fixed date, since I'll inform the council also for respondent, petitioner
Vijay.
in item number 3. Yes, they're coming from outside, so.
Okay, this matter
On Lordship, 8th of May.
8 May. Start. Miss, her presence may also be called. Huh? In the 3, no one appears on behalf of the.
Yes, yes.
Okay.
Petition.
No one appears on.
Appellant, sorry.
For the petition, for the parties. When this matter of after.
On 8th of May, Lordship.
Okay, on 8. Okay.
Oblige.
Please, the Lordship. May I please, the Lordship?
Yes.
My Lord, I am appearing in this matter from Guwahati, my Lord, due to unavoidable circumstances, my Lord.
Okay, okay.
All the last 4 occasions I physically appeared before the court, but due to some urgent matter before the principal bench, my Lord, I have to appear in video conference, my Lord.
Okay,
This
please.
is, my Lord, this is regular bail application. Here, my Lord, basically case falls under section, my Lord, 420, my Lord, and statutory period is 60 days, my Lord. And my humble submission is that, my Lord, in this regard, I have already submitted one affidavit in the record, my Lord, that statutory period is already over, my Lord. And today, my Lord, as per my calculation, subject to my learned public prosecutor says, my Lord, today 65 days, my Lord. So kindly, my Lord, your Lordship may be graciously pleased to, my Lord, release these 2 petitioners on, my Lord, default bail, my Lord. And another, my Lord, aspect is in this matter is this, my Lord. Earlier occasion, your Lordship asked me whether these 2 petitioners are government employee or not, my Lord. They are not at all government employee, my Lord. But here, my Lord, investigation of getting officer, my Lord, due to misunderstanding, my Lord, added, my Lord, section 409 also, my Lord. But they are not government employee. Therefore, my Lord, section 409 is not at all attracted in this matter, my Lord. This is my humble submission.
Your Lordship, on the last occasion, the Lordship is directed to file their affidavit, Your Lordship. Lordship, there is a section of 409, Your Lordship, and the statutory period for 409 is 90 days, Your Lordship.
90 days.
Yes, Your Lordship. And therefore, there is no question of default bail, Your Lordship. Otherwise, Your Lordship can take up the matter on the merit, Your Lordship. I have the CD, Your Lordship, updated CD.
To this effect, my Lord. To this effect, my Lord, if, my Lord, my learned friend does not agree that, my Lord, default bail, my Lord, I beg to, my Lord, refer one Supreme Court judgment, my Lord. Already I have put off before the, my Lord, bench master this judgment, my Lord. I beg to refer this judgment, my Lord, 2012 8 SCC, my Lord, page 547.
Just a minute.
547, and, my Lord, the relevant paragraph is, my Lord, 13.
Just a minute.
My Lord.
So she says that there is 409.
Yes, Your Lordship.
409 also IPC.
Yes, my lord.
And then the statutory period
Is 90 days, my lord.
is 90 days.
My lord.
And the petitioner, the accused has only completed 65 days.
65 days. But here, my lord, petitioners before your lordships are not government employee, my lord. But as per section 409, my lord, the accused must be, my lord, government employee, my lord.
No, that's absolutely
In
wrong.
this regard, my lord, I place honorable Supreme Court judgment, my lord. This is, I referred, my lord, there is a paragraph, my lord, interpreted, my lord, this section, my lord. And lordship, may I read, my lord, section 409, my lord?
Yes, yes. Just a minute.
My lord, 409 IPC is criminal breach of trust by public servant or by banker, merchant, or agent, whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker, attorney, or agent commits criminal breach of trust in respect of that property shall be punished with imprisonment for life or imprisonment for of either description for a term which may extend to 10 years and shall also be liable to fine, my lord. Now, my lord, I beg to refer the Honorable Supreme Court judgment, my lord. This is 2012 8 SCC page, my lord, 547, my lord. I have placed before the, my lord, bench master this copy. My lord, here paragraph, under paragraph 13, it is provided by the Honorable Supreme Court, my lord. Paragraph 13, it is, my lord, 409 is quoted, criminal breach of trust by public servant or banker, merchant, or agent, my lord. Now, paragraph 14, my lord. In order to prove the offense of criminal breach of trust, which attracts the provision of section 409 IPC, the prosecution must prove that one who is in any manner entrusted with the property in his case as a dealer or fair price shop dishonestly misappropriate the property commits criminal breach of trust in respect of that property. In other words, in order to sustain conviction under section 409 IPC, two ingredients are to be proved, namely that the accused, a public servant or a banker or a agent, was entrusted with the property of which he is, my lord, this is important, my lord, he is duty bound to account for. And, my lord, the accused has committed criminal breach of trust. What amounts to criminal breach of trust is proved under section 405, my lord. So here, my lord, he would have been, my lord, a legally entrusted person, my lord, and he is the public servant, my lord. But here, my lord, petitioner before your lordship is a, my lord, not a public servant, my lord, and he has no, my lord, legal authority to any kind of monetary deal with the informant, my lord. Therefore, my humble submission is that, my lord, this, my lord, section 409 is not attracted in this case, my lord. So, my lord, section 4020 remains, my lord, and under 4020, my lord, there is a statutory period is, my lord, 60 days, my lord. And in this regard, my lord, regarding, my lord, unnecessary adding of, my lord, section in a particular case, and importantly, my lord, this 409 case, my lord, another, my lord, judgment I have placed before the your lordship. This is, my lord, passed by the Bombay High Court, my lord, regarding regular bail application, my lord, and paragraph, my lord, 13, my lord, I beg to refer, my lord, in this judgment, my lord. Here, my lord, Honorable Bombay High Court, my lord, taking reference of the judgment of the Honorable Supreme Court, it is held that, my lord, this Honorable Court, my lord, while considering the bail application, is not bound by the mere adding of section by the, my lord, inspector, my lord, investigating officer. Therefore, my lord, I beg to refer section 13 of this order passed by the, my lord, Honorable Bombay High Court, my lord, regarding a regular bail application. paragraph 13, my lord, I may be allowed to read out, my lord.
Please.
Paragraph 13, my lord, there is no manner of doubt that the investigation is within the province of domain of the investigating agency. However, that does not mean that the court is almost all aspect cases would be bound by the invocation of a particular section against the accused by the prosecuting agency. This is because the level of the section or the provision invoked would not be decisive. You hold the otherwise would amount to placing the said right at the mercy of the investigating agency and would indirectly result in the magistrate abdicating the duty to enforce the right wherever necessary. Thus, the court would be required to look into the generality of the allegations made and the materials collected. In a given case where expressly the provision is not attracted, the court may not be bound by the same. Although there is no requirement for the investigating officer to obtain permission from the magistrate or such edition as held by the Calcutta High Court in Sayantan Chatterjee Supra, the magistrate is not precluded from looking into the facts and the materials collected whether the offense is expressly made out or not. The matter depends on the facts and circumstances of each case. For instance, where the investigating officer invokes section 326 of IPC, however, the medical report does not expressly show that the victim was suffering a grievous injury within the meaning of section 320 of IPC, or a case where section 409 of IPC is invoked and admittedly the accused does not fall under any of the 7 categories mentioned in the said section. Merely the accused is neither a public servant. This is important, my lord. Namely, the accused is neither a public servant nor a banker, etc. I would hasten to add that where, however, the facts and circumstances, this is not necessary, my lord. But here, my lord, this humble petitioners before your lordship is not government employee, my lord. Therefore, this section 409 is not attracted, my lord. Even otherwise, my lord, in this case, on merit, my lord, apparently, my lord, I have, my lord, annexed one agreement between the parties. This is, my lord, page 21, annexure 3. And, my lord, petitioner before your lordship is, my lord, informant's tenant, my lord, residential tenant, my lord, and they made one, my lord, agreement between the parties to give some works, my lord, contract works to the, my lord, informant, my lord, as per the agreement page 21, annexure 3. And it was provided that, my lord, rupees 50, my lord, page, my lord, 21, annexure 3, my lord.
Okay.
My lord, clause 1, my lord, it is in between, my lord, petition number 1, my lord, and informant, my lord. That the second party has taken a sum of rupees 50,000 first party only from the first party regarding the business purpose. That the second party agrees to give a contract work to the first party from any department, whether it may be from the central or the state schemes as feel deemed fit and proper. That if the second party fails to give work order or any other works to give as a promise to first party, then the second party will return the principal loan amount to the first party within the 1 week from the date of receiving the amount to the first party, my lord. So, my lord, this is a, my lord, even otherwise, my lord, this is a agreement between the two parties, my lord, though this is, my lord, illegal agreement, but on mutual understanding, my lord, money was taken, my lord. But as per the FIR, my lord, when he did not return the money, my lord, only then, my lord, after belated stage, my lord, after more than 5-6 months, my lord, this FIR was lodged, my lord. In this regard, my lord, I want to refer to anticipatory bail application my lord, bail granted by the Honorable, my lord, Principal Bench of our High Court, my lord. This, my lord, page 23, my lord. Page 23, my lord, our principal.
Okay, okay. So, even in the merit also, it appears that this.
No,
matter
Your
relates
Lordship.
to the
No, Your
civil-
Lordship. If I may, if my learned friend is done with his submission, Your Lordship, I would place the CD as well, Your Lordship.
civil.
Now, if I may take Your Lordship to the FIR, Your Lordship.
Only, my lord, just another two orders, my lord. I will end, my lord.
Yes.
My lord, page, my lord, this Honorable Court's order, my lord, page 23, my lord. And my lord, this is bail AB number, my lord, 3473/2022, my lord. It is, my lord,
Okay.
Sir M. Borbuya, then, my lord, relevant portion, my lord, page 24. My lord, paragraph 24, my lord, the FIR has been lodged by the general manager of the vehicle dealer company that the contents of the FIR disclose that over the issue of purchase of vehicle, a dispute crop up between the dealer and the purchaser. This court is of the opinion that the dispute narrated in the FIR discloses a civil dispute only, and therefore the petitioner does not deserve to be detained in the custody for the aforesaid fact. His prayer for anticipatory bail is allowed. Even, my lord, without calling for CD, my lord, the anticipated bail was granted, my lord. And another, my lord, judgment order, my lord, page 25, my lord. Page 25, my lord, AB 352/2023, my lord. Here also I appeared, my lord. Had
Okay,
M.
okay.
And, my lord, page 26, my lord. The informant and the present petitioner are partners, and both of them together took a contract. The money was to be deposited in the court of the informant, but somehow the money earned on the contract was credited in the account of the petitioner. After hearing the learned counsel for the petitioner, this court is of the opinion that the informant has other forum to seek relief for allegations brought against the petitioner, and the petitioner does not deserve to be detained in custody for the said allegation. Therefore, the pre-arrest bail praise is allowed. Accordingly, it is hereby provided that such a.
Okay. What is there in CD? What is there in CD against the accused other than this?
He himself has admitted, Your Lordship.
I mean, it's
Taken
still
money.
admitting.
If
But then
my
the agreement also, it shows that.
no, Your Lordship.
money
Therefore, I was
from the
taking. Therefore, I was taken, Your Lordship, to the FIR, Your Lordship. If Your Lordship comes to the FIR, Your Lordship will know. If I may read, Your Lordship. Page number 17.
Yes.
Yes, Your Lordship. That Sri Kaji Bhabibur Rahman approached me and promised that he'll give contract work worth rupees 50 crore from central government or state government project for which he had taken crores of money from time to time.
That is why I was asking whether this person, the accused, is whether the government employee or not.
Your Lordship will see 409. 409 does not speak only of government employees.
No, no. I'm not talking about the 409, but
Yes.
this person,
Yes.
why he had to apply to anyone
Yes.
XYZ to give a contract.
Yes, Your Lordship. I'm not privy to their conversation and on which basis the promise was made and on which basis trust was implanted on
He
the.
used to give money, and then later on came into an agreement that it will be.
No. If I may, Your Lordship, if I may read the FIR in a serial manner, Your Lordship. That Mr. Rahman has taken from me 10 lakhs on 19/6/2023, 32 lakhs on 16/3/2023, and 10 lakhs on 3/3/2023 through RTGS. That Mr. Rahman has taken lakhs of money from me through Google Pay. That Mr. Rahman has taken 50 lakhs from me on 7/8/2023. This is the agreement, Your Lordship. By cash with promise that he'll give contract work within 1 week, failing which he agreed to pay back my principal amount within a week, but all his promised and written agreement failed miserably. That Mr. Rahman reached Itanagar. Your Lordship will see the actual incident happened here, Your Lordship. Mr. Rahman reached Itanagar on 29/1/2023 and asked for final payment. That is 1 crore to get project work within a week. Since he was staying in my rent house at Economic and Statistic Colony, Itanagar, so I managed 1 crore and handed over it to Mr. Rahman on 1/2/23. I was waiting for good news as he told me that as per the earlier agreement, the work order is bringing by his close officers. But today on morning 2/2/24 at around 6 a.m. when I went to his room, then found that his room is kept open and nobody is present inside the room. The bag which I handed over to him along with cash is found empty in nearby bushes plant. He and his associates fled away from the room along with cash rupees 1 crore. He initially picked my call and apprised that he is outside the room, but now he has switched off all his mobile number. Now your lordship will see, even if the contract, since we are not privy to what kind of contract that was, your lordship. There was a contract. Subsequently, monies were taken as in the name of processing fee, your lordship. On the final day, when this amount was handed over to the accused, your lordship, he was also
either it was an illegal transaction or it was a loan money.
your lordship.
So you see the agreement then.
Yes, sir.
Will return the principal loan.
Yes,
amount to-
that is only with regard to 50 lakhs rupees. That was given in the month of August, your lordship. Now, your lordship will see on the day when the incident happened, that is on 2nd of February, your lordship. He had taken another 1 crore, he had fled it, your lordship.
We do not know whether he has given or not.
No, your lordship will see. Therefore, my CD is with me, your
He
lordship.
is also not alleging that he is a government employee and promised to give.
Your lordship will see contracts. If your lordship, any contracts outside your lordship, even in the state, your lordship, there are always agreement between businessmen.
Either it is illegal agreement or it is a loan amount.
Yes, that I'm not privy to that, your lordship. Now, even your lordship will see 409 speaks also of the brokers and the judgment that my learned friend has cited, your lordship. There is also a word named dealer, your lordship. There is always a middle person who engages the department as well as to the business person if there is any kind of contract, your lordship. Now, if your lordship will see my CD.
He should
Even
be,
if your lordship take the 50 lakhs rupees, your lordship. 50 lakhs, the agreement amount, your lordship. That apart, your lordship, on the day of incident.
In the CD, what you want me to see?
The statement of the accused, your lordship. The statement of the accused, your lordship. That's yes.
with all respect, my lord, I beg to add one thing, my lord. Whatever his capacity may be, my lord, all the capacity should be his official capacity, my lord. But he has no, my lord, any official capacity, my lord.
I'm in the case number. This is
Item number 9.
9. The 5 and 9 are the same.
5 and
9.
Arising out of same FIR.
Same FIR.
Okay.
In the meantime, my lord, I have petitioners from the petitioner side, my lord, 10 lakhs rupees paid, my lord. And I have, my lord, given the undertaking in the bail petition itself, my lord. I am ready to return his, my lord, money as per the, my lord, agreement, my lord. It is a purely, my lord, a monetary dispute between the parties, my lord. Of course, my lord, hardly, my lord, he may have cheated, my lord, some extent, the informant, my lord. I may not, my lord, rule out this aspect, my lord. But here, my lord, section 409 may not be added, my lord, to detain him, my lord, till, my lord, 90 days, my lord. This is my humble submission, my lord. For, my lord, attracting section 409, my lord, he has to do anything, my lord, in his official capacity, my lord. But this humble petitioner before your lordship, my lord, has no official capacity to deal with the monetary transaction with the informant, my lord. Therefore, my lord, this section, my lord, 409, my lord, due to misunderstanding, my lord, I added, my lord. My learned friend, my lord, from the government side, my lord, some extent, my lord, they are rightly submitting, my lord. But that does not mean, my lord, this is a case of 409, my lord. And, my lord, there are, my lord, lot of other Supreme Court judgment, my lord. I am ready with those judgment also, my lord. That, my lord, these are, my lord, monetary transaction, my lord. They have, my lord, alternative remedy. And, my lord, in the FIR, my lord, it is out and out, my lord, they stated in the FIR that my lord, this is transaction what deal with, my lord, due to out of, my lord, their understanding, my lord. And this petitioner is the, my lord, residential tenant of the informant, my lord. They have, my lord, long friendship, my lord, and they are well known with each other, my lord. And monetary transaction was done, my lord. And when, my lord, he did not, my lord, fulfill his, my lord, promise, my lord, then FIR was, my lord, filed after a long late, my lord. Prima facie, my lord, allegation, my lord, made in the FIR, my lord, some extent may be correct, my lord. But whatever money was given, it is, my lord, apparently, my lord, stated in the FIR that he, with his own consent, by his own hand, my lord, given the money to the petitioner number 1, my lord. And petitioner number 2 is, my lord, just a neighbor of the petitioner number 1. And he was found in his house on that day of arrest, my lord. Therefore, he was also picked up, my lord. But there is no allegation against the petitioner number 2. And in the petition itself, my lord, I have categorically stated at page 6, my lord, that, my lord, this petitioner is ready to return the money, my lord. And petitioner, my lord, is well contacted.
Now the status of the case.
First page, your lordship.
Okay. FIR was lodged on which date?
FIR was lodged on 2/2/24, your lordship.
Oh.
Now, if I may, your lordship will see the statement of the accused person, your lordship. He says that the informant is a class 1 contractor, your lordship. Now, class 1 contractor, your lordship, for any kind of work, your lordship, if it's outside the jurisdiction, it has to be informed by it has to be informed by the agent or some broker, your lordship. He was working as an agent and broker, your lordship.
Section 409 also mentioned about the agent. What do you say about that? Agent.
My lord, agent, my lord, as per the section and the judgment of the Honorable Supreme Court, my lord.
He acted as agent.
Yes, my lord, he should be, my lord, lawful agent, my lord. But he should be, my lord, acting in the official capacity, my lord, not in the private capacity, my lord. Therefore, my lord, in these two judgment, my lord, I have placed before your lordship. It is, my lord, held by the Honorable Supreme Court as well as the Bombay High Court, my lord, that, my lord, he should be, my lord, doing all this monetary transaction in the official capacity, my lord. He, my lord, honestly, my lord, I am submitting, my lord, he perhaps, my lord, cheated him, my lord. That much I cannot, my lord, deny before your lordship. It would be unfair, my lord, because he has at least, my lord, some monetary transaction for the name of, my lord, contract work, my lord. But this, my lord, at any stretch of imagination, my lord, this is not a case of 409, my lord. This is my humble submission. And to this effect, my lord, I have also submitted one additional affidavit in the record, my lord, stating that, my lord, this is not the case of 409.
Additional affidavit there.
Additional affidavit, my lord.
IA or additional affidavit? IA. Okay. to release under one, this is under 160. In item number 9, and this is in which item?
In the additional affidavit, my lord, I have stated at paragraph 2, my lord, the accused petitioner is not any government servant, and the alleged monetary transaction was admittedly not taken place in the discharge of any office.
IA 24.
No, my lord. In my case, my lord, bail application 20, my lord, I have submitted one additional affidavit. It may be, my lord, below the petition, my lord. My lord, paragraph 2, my lord. May I read, my lord?
Just a minute. Okay, the amount, some amount also seized.
Out of, yes, your lordship,
And
two,
then even the round passbook in which the amount was deposited has been held. So, what do you say about 409?
409, if I may read the section, your lordship, if I may be allowed.
Hmm.
Whoever being in any manner entrusted with property or with any domination over property in his capacity of a public servant or in a way of his business, your lordship, as a banker, merchant, factor, broker, attorney or agent. There are varieties, your lordship will see, merchant, factor, broker, attorney or agent. It does not speak only of public servant, banker, merchant or agent, your lordship.
My lord.
Now, where is the question of, there is a submission that he has to be a registered agent or any
Yes,
kind
yes.
of agent.
Yes, my Supreme Court judgment, my lord, 2012,
Lordship
my
will
lord.
see, broker is never a, brokers are also never a registered brokers, your lordship.
Ingredients
There are
is given.
factors of people, your lordship. We'll see also the word factors, your lordship. The 409 is not only with regard to any registration of any person in any form, your lordship.
My lord, both the judgment on this point, my lord. And Supreme Court, my lord, held the, my lord, ingredients of section 409, my lord, under paragraph 14 of my judgment, my lord. Lordship, my lord, may I, my lord, revisit the, my lord, judgment ingredients, my lord, paragraph 14, my lord.
No, this is item 5. Yes, no. So, please.
Paragraph 14, my lord, in the Supreme Court judgment, my lord, regarding ingredients of the 409, my lord. 2012 8 SCC, my lord. 8 SCC, my lord, paragraph 14, my lord. Below the, my lord, 14, in order to, my lord, last two lines, my lord, paragraph 14, my lord, in order, in other words, in order to sustain conviction under section 409 IPC, two ingredients are to be proved, namely, the accused, a public servant or a banker or an agent, was entrusted with the property of which, my lord, this is important, of which he is duty bound to account, my lord.
Okay. Okay, I'll pass order, huh? And what is your
My lord.
case item?
Item number 9.
9. This is 5, no? So, I'm keeping the CD for the time being, huh? Miss Jenny?
Yes, Your Lordship.
Okay, this is item 9. So what is your case?
It's the same case, Your Lordship.
Same case?
The same
You are
case.
another accused?
Another accused. I have just accompanied.
You also accepted money?
No, yes, Lordship, actually, some money has been given to me also, but
Your name?
Mustaq Ahmad.
This is, okay, Mustaq Ahmad has also given 161 statement.
Yes, Your Lordship.
Mustaq Ahmad.
If I may allow to note.
Please.
Your Lordship, in this case, accept that I have taken money from the main alleged accused, but as far as the police asked for the money, I have returned back the money. And I didn't know about those deed of agreement also between that Habibur Rahman and the complainant.
Habibur Rahman. How many accused total? How many accused are there? 3.
3 accused has been arrested.
3 has been arrested, Your Lordship.
Okay.
One, the driver of the Bolero, as well as he is absconding, Your Lordship, also. Here one. 3 of the accused has also come under AB, Your Lordship. They were granted interim, and the matter has been fixed after 2 weeks, Your Lordship.
Who has been granted?
3 alleged accused were granted anticipatory bail, Your Lordship. Interim bail, Your Lordship, in anticipatory application.
This is fixed on, my lord, 23rd of April, my lord. These are AB, my lord.
This accused Mustaq, and then what is that? 5 Kaji Habibur.
And one Giyas Uddin is also.
Yes, all of them were arrested
on the same date, Your Lordship.
Okay.
5.
So who are in AB?
AB, there are 3 other persons, Your Lordship. The wife.
Altogether, how many
They are, my
persons
lord.
here?
There are. If I may.
Wait.
My lord, I am giving the name, my lord. I am ready with the name, my lord. Kaji Abidur Rahman, then Kaji Tayabur Rahman, then my lord Srimati Sultana Begum Majumdar. She is, my lord, the wife of petition. Today's petition number 1, my lord. And this Kaji Abidur Rahman and Kaji Tayabur Rahman, brother of the petition number 1, my lord. And Sri Kaji Abu Bakr, my lord, he is cousin brother of today's petition number 1, my lord. My lord, one important aspect is that, my lord, in the paragraph 6 of my bail petition, my lord, item number 5, I have undertaken, my lord, to return these 50 lakhs, my lord. And towards this, my lord, undertaking, in the meantime, during the pendency of this petition, I have returned 10 lakhs to you.
Undertaking
To return this, my lord, agreement, my lord, 50 lakhs rupees at paragraph 6 of the petition, my lord. And towards this, my lord, in the meantime, family members.
Okay.
Paragraph 6, my lord. And this submission may be recorded, my lord, my submission, my lord. Paragraph 6, my lord, he has given undertaking that, my lord, this agreement amount rupees 50 lakhs, my lord, he will return. And my lord, informant is, my lord, out of court is happy with this amount, my lord. And my lord, towards this, my lord, I have returned 10 lakhs from the family members of the petition number 1 in the meantime.
10 lakhs. Have you stated in your petition that you have already returned 10 lakhs?
Pro RTGS, my lord. Informant is happy with now with us, my lord, about this, my lord, undertaking, my lord, out of court. Perhaps he is not disclosing before the court, my lord, because it may be contradictory to the.
Where have you stated that you have already paid 10 lakhs?
My lord, 10 lakhs it is stated, my lord, in AB, my lord, because after filing this, my lord, I have returned, my lord. In the AB petition, which is fixed on 23rd, my lord. My lord, submission may be recorded, my lord.
This is here. AB. AB for whom? The same person?
No, my lord, his family members, my lord, because some money was recovered from his, my lord, family members' account number. They were also, my lord, being searched by the.
AB is item 9.
No.
No, my lord, AB is not today, my lord.
AB is not listed today, Your Lordship.
Not listed.
My submission may be recorded, my lord, 10 lakhs in the meantime, towards the undertaking at paragraph 6, my lord, 10 lakhs in the meantime returned, my lord.
Total, how much did you?
50 lakhs, my lord, 50 lakhs he will repay, my lord.
50 lakhs you are you have undertaken to return.
Yes, my lord.
10 lakhs already returned.
Yeah, during the pendency of this bail petition, 10 lakhs return, and informant is now happy with us, my lord. Now informant is happy with us, my lord, as per my instruction, my lord, with this 50 lakhs, my lord. My lord, obviously, my lord, out of anger, my lord, emotion, my lord, he has some exaggerated in the FIR, my lord. Actually, true fact is this, my lord, 50 lakhs, my lord.
How much amount you are
50 lakhs, my lord.
Total, how much amount he has taken?
My lord, he is, my lord, alleging, my lord, much more. But out of court, my lord, he is happy with our this undertaking at paragraph 6, my lord.
Now, how much the accused is admitted to have taken?
50 lakhs, my lord. 50 lakhs.
50.
50 lakhs, my lord. As
So
per
now
this
he is going to
agreement.
return 60. Now he is going to return 60. 10 plus
No, my
50.
lord, next 40 he will give, my lord.
Okay. Hard, Mr.
A.M. Borbiya.
Land counsel for the petitioner. I have also heard Mr. Boni. And additional people. So this will be in item
9, Your Lordship.
5. No, this is 5.
This is 5, Your Lord.
Oh, okay. Order I'll do this, Okay. Let us one by one. Yours matter over, and then yours is also same.
Same, Your Lordship.
So you have also.
No,
That
I have-
means, according to him, the petitioner, sorry, the accused has already paid 10 lakhs,
Yes,
and then now he is ready to pay back 50 lakhs.
yes, Your Lordship. The transaction is between the Habibur and the complainant, not with me. I have taken the money not from the complainant also, because I have accompanied the Habibur Rahman to the Itanagar. So he have given me some money.
Now, what is your case then? Just a minute. His case is that he has accepted earlier money.
Yes.
Now he is returning.
Yes, Lord.
And your case is?
My case is only that I have accompanied with him, so I have taken money from the Habibur Rahman. That's why I was also arrested.
Money from Habibur Rahman?
Yes.
How much you took?
5 lakhs. So as far as the police asked the money, I have returned back the money also.
Already returned?
Already returned. Yeah.
And my lord, another important aspect is that, my lord, in the forwarding report, Lord, almost 1 crore rupees they, my lord, seized from the bank account. In the forwarding
Just
report,
wait,
Lord.
just wait.
My lord, obligement.
No, this is Nili Likha.
The
Accused name?
Mustaq Ahmed Majumdar.
Mustaq Ahmed.
that is the one.
Yes. In the earlier bail, you just record one line, that the accused has already, during the pendency of the case, the accused has already paid that rupees 10 lakhs to the accused. You have a receipt of payment of that 10 lakhs?
Yes, my lord. This receipt, my lord, I have annexed in the AB, my lord.
AB.
AB, my lord.
When the
Lordship,
AB is to be, when the AB is to be listed?
23rd, my lord.
Whether AB is 23rd?
23rd, my lord.
Okay.
My lord, my submission may be recorded, my lord, towards the implement of the, my lord.
Just a minute. AB for whom? Who has
Your
filed
Lordship,
AB?
Your Lordship, he is not the counsel for the AB, Your Lordship.
No, I am counsel, my lord.
AB filed for praying for whom?
AB form, my lord. No, my lord, family member, family members.
Answer my question. Answer my query. AB
My lord.
was filed for.
My lord, family. By
who filed
family.
AB?
Family members of the, my lord, accused number 1 today, my lord, in item number 5.
No. He is, this accused is, the name of the accused is? Kaji.
Kaji Habibur's, my lord, family members, including his wife.
So AB is for grant of anticipatory bail for whom?
My lord, family members of my lord Habibur Rahman. Today's petition number 1, my lord.
Today's petition number 1.
Yes, my lord. Family members, my lord. All are family members.
He is also accused.
Accused because, my lord, some money was recovered from their account, my lord, also.
Okay. And the accused has also undertaken to repay sum of rupees 50 lakhs. 50 lakhs undertaken.
Yes, my lord.
To pay within.
Within, my lord, within 1 month, my lord.
Has also undertaken to pay back rupees 50 lakhs to the informant within 1 month. Okay. Okay, and in your case, you have only accepted, and then that was seized, or you had just paid back?
No, it was taken, some of the amount was taken by, from the house only, and from the bank also. From the police, they have seized.
No, how much exactly? How much?
5
amount?
lakhs.
5 lakhs total
5.
they have
Yes,
recovered.
recovered. As I have taken 5 lakhs from the Habibur Rahman. At the time of arrest, when the police asked the money, then in the immediate, we have returned back the money.
Where do we find that you have paid back? Or
It should be in the CD also.
not in ADPP?
Your Lordship, if Your Lordship will see the last page, that's a status report on the 1st of April, Your Lordship. There is.
Just a minute, just 1 minute.
Honors.
Oh.
Right.
Okay, so this is, your accused name is?
Mustaq Ahmed Majumdar.
Mustaq Ahmed. So from bank, they have recovered how much?
From as far as their
and then from, just want to record.
5 lakhs.
Huh?
5 lakhs.
Total 5 lakhs they have recovered.
not from the bank, from home. Two lakhs 46,000. That much I know actually, and from other the remaining might taken from the bank.
So how long you have been in the jail?
It's now 73 days.
No, not 73. Not 73.
Okay,
Oh,
you
no,
were
sorry,
arrested,
60.
okay, and here
More
in
than
this
60 days.
case, Mr.
El Nara.
L.
El Nara.
Hmm. and counsel for the petition, in item 9, huh? Or Miss Jeannie also, start, huh? Here, just record a point that he was arrested on which date?
5/2 of 24, 5 February.
2024.
It's more than 60 days.
Police recovered 2.65 lakhs from the bank account and 2.46 lakhs from home. Okay. He only accompanied the main accused, Kaji Habibur. Okay. Okay, so what you wanted to show in the status?
The
Page?
last page, there is different status report, Your Lordship, that was given in the month of March when the CD was called for.
Yes.
If Your Lordship pick up the whole bunch, last make page over there.
This bunch?
Full bunch, Your Lordship.
Okay.
The whole bunch.
Status?
Yes, Your Lordship. That it's a loose sheet status, Your Lordship.
Okay. Okay. So this is the status report for?
Since
The
the CD was
same
called
time.
on, yes, Your Lordship. No, since the CD was called also on earlier occasion, Your Lordship, prior to giving the AB, Your Lordship,
Okay.
this status report bring out a clear investigation process, Your Lordship.
This was on 19 March.
March, yes.
So this is in respect of both the
Both the accusers, Your Lordship.
Mustaq Ahmed, Kaji Habibur. Okay. So I'll pass over.
Yes, Your Lordship.
So please you can.
Yes,
My lord, my lord, my lord, my lord, kindly I may be allowed to submit this RTGS receipt through the bench master, my lord.
Okay.
Xerox copy, my lord. 10 lakhs, my lord. Yes, my lord.
Okay.
Through the bench master, my lord. Right now, my lord, my assistant will, my lord, forward, my lord.
Okay. Okay.
Deeply obliged, my lord.
Yes.
My lord, item number 3 and 4, my lord, due to traffic jam, unable to appear at time. Only 5
So
minutes
next
late.
date already fixed.
In
Your
case
presence
you
will be
items your
recorded.
lordship, my appearance may be shown.
Okay. So in the item number 3,
3 and 4.
instead of non-appear, Mr. I. Ahmed appear, hard Mr. I. Ahmed, Line Counsel for the appellant. And who is a respondent? No one appeared yet appears.
No appellant.
Is prayed for the same. Huh? It is
Item
fixed
number
on.
3 for appellant, item number 4 for respondent.
Okay. In the 4 then, Mr.
Director of
Ahmed.
Industries.
Mr. I. Ahmed. Respondent number? Your correspondent number?
It is respondent number. Respondent number.
Respondent number Olum Moyong. Christopher Parme is their learned advocate.
No, respondent number. Tell me the respondent number.
Forward, কিহত আছে আপুনি industry কিহত আছে 4 item number industry to কিহত আছে industry কিমান
Director of Industry.
Director of Industry is respondent number.
Respondent number 1. Director of Industries appellant in item number 3. In item number 4, respondent. So I am appearing for in both the cases.
Department of
Okay, respondent
For respondent.
for Director of Industry. And
in item number 4 for Director of Industry and Secretary.
No, Director of Industries, Secretary.
And Secretary in item number 4.
item number 3 also. Just leave it.
My lord, may I leave from item number 5, my lord?
It's over, it's over.
My lord, deeply obliged, my lord.
Okay. You are for industry.
For item number 3, for Department of Industry, yes, and in item number 4, for respondent of Department of Industry, Director of Industry and Secretary of Industry in item number 4.
Director and secretary also.
Okay, fine.
Okay, in the respondent number 3, after,
And in 3 for appellate.
also heard after Dangian, also heard Mr. I. Ahmed representing the respondent. See the respondent, the director industry, director, secretary, director and secretary industry. Okay, and see the respondent, Okay, okay, that's fine. Next. Yes.
Six. Item number 6, 7, and 11 are matters arising out of same FIR, Your Lordship.
6, 7,
And 11.
6 already withdrawn. I'm referring 11. Then let us take up the 7 first. One by one.
6 between.
This is 7.
6 between. Your Lordship, in this, I have got a phone call this morning by the council, Your Lordship. He's from Guwahati. He said he won't be able to come, Your Lordship. I had got a call from the council in this item number 7, Your Lordship. He stated that he won't be able to come due to some difficulties, Your Lordship.
Okay, so the record was called for record
Yes.
produced earlier? No.
He was present on the earlier occasion, Your Lordship.
So what do we do?
Your Lordship, his absence may be recorded, Your Lordship. Meanwhile, this matter.
No one appears on behalf of the petitioner. Miss Jenny, Narayan, PP, staff. Page paid. List this matter after 2 weeks.
Yes, Your Lordship.
2 weeks. The land additional PP shall produce the updated case diary on the next date. Okay. Now 8.
8.
8 also same.
No, Your Lordship. 11 is same, Your Lordship. 11.
No, 8.
No, different matter.
In item number 8, I'm being led by Senior Counsel Mr. D. Modification. He is engaged in some other court. Therefore, I pray that this matter may be taken up at 2.
After some time. Okay. Later on, after some time. Okay. Jane also AB, are you okay?
Yes, Your Lordship. The council is not present today, it seems.
No one appeared on call. So, Miss Jeannie Lanet Edison PP is present. In absence of the accused, the case stands adjourned. List this matter after 2 weeks. Okay. Okay. Yes.
Yes, Lordship, but this is, the application of the portrait here, Lordship. Is there was for?
Yes,
Yes, Your Lordship, we have received the CD.
CD was called for.
Yes.
Yes.
Yes, Lordship.
Hmm.
Lordship, here the applicant, Lordship, Kosik Das, he was working as a manager with the complainant since last 2 years without any advance remark.
Manager with the informant.
Yes, yes, Lordship. So, since
Whether he
last,
said that,
since last 2 years, Lordship.
let us see the allegation.
Lordship,
Page
may
15.
kindly come to page number 15, Lordship. This is the copy of that file.
Someone has stolen. Someone.
Yes, Lordship.
If he knows,
Married that file.
yes, please.
To the officer in charge so and so, with due
Leave
respect,
that with,
we
yes.
would like to throw your kind attention that forgery has been to my bank account number so and so from SBI, Ganga SBI branch. Herein someone has stolen my check number so and made false signature of mine to transfer the RTGS from my account without my consent, knowledge of amounting to ₹35 lakhs credited to the account number so and so, IFC so and so, beneficiary to namely Dilip Setia of Biswanath Chariali on dated 6/2/24, who is unknown and stranger to me, whom I
So
never-
this Dilip Sakya has been working with this informant for 2 years,
Kosik Das, Lordship.
not Dilip Sakya.
No. Kosik Das. He is
Okay.
the applicant, Lordship.
Kosik Das is working with,
With
The informant.
Informant, Lordship, as a
okay,
manager.
and then what, and then this,
Tidip Das was in item number 6, who has withdrawn the bail application, Your Lordship.
okay,
He was the main accused, Lordship. The amount of 35 lakhs was credited into the account of that Dilip Setia.
Dilip Sakya,
Dilip Setia. Dilip Setia. The who was the applicant in item number 6, but this morning he has withdrawn the. Lordship, this was the allegation, Lordship. In the last prior, Lordship.
no,
I-
just a minute, more for, full signature.
Yes, Lordship.
TD.
Dilip, sir.
So it was credited in the account of Dilip Sakya.
Dilip, sir.
So this Dilip Sakya is stranger to the informant.
Informant.
Okay, last, which one?
Yes,
So
sir.
kindly,
In this regard, I would like to apprise you that me, Kosik Das, who has been working as a manager with me, is missing from 7/2/24 after revelation of that incident.
okay, Kosik was also
Yes,
missing.
yes. He has been changing his statement over the phone and misleading us. It is suspected that he must be involved in this case, Lordship. I am the Kosik Das, Lordship. So,
You are Kosik?
Kosik Das, Lordship.
Das.
Yes.
Hmm.
So it is, against me, it is alleged that I have been also suspected to be in the case,
Hmm.
Lordship. Lordship, however, the fact is that, Lordship,
So what is the finding? What's this, the
Yes, yes, Your Lordship.
evidence still collected till now against Kosik, the present applicant?
Since he had, he immediately left his place, Your Lordship.
Hmm.
His place was also searched, wherein there were papers, wherein they were practicing the signature of the complainant. Your
This
Lordship.
Kosik also?
It's called, in the room of Kaushik Das, Your Lordship, where he was staying prior to his
Okay, it was found.
absconding. They were scribbles, wherein they were practicing the signature of the complainant, your lordship.
Okay.
Also, your lordship, if your lordship will take up the status report, your lordship,
Hmm.
which has very.
Yes,
Now this check was given to Tidip Das, your lordship.
check was given to.
Tidip Das, your lordship. If your lordship will see to find it, serial number 3 of the status report, your lordship, the first page.
Yes, I have done. Yes, three.
Yes.
Three of the status report.
Yes.
Yes. So these papers were found and seized.
Yes, your lordship. Now, if your lordship will come.
Whether these things have been sent to FSL.
Yes, your lordship, along with the check, along with the
Has
fourth
the
check. Fourth check.
Has
Yes.
the report come back?
No, your lordship.
Okay.
Now, if your lordship will also come to page number 3, your lordship, of the report, your lordship. Serial number 17 is the CDR, reference to the CDR report, your lordship.
Hmm.
Wherein there were continuous conversation between both the alleged accused on and before the date of incident, your lordship. Now it's serial number 19.
Yes.
41A notices were given, your lordship, twice. However, they are absconding, your lordship. However, through phone, when the IO had contacted Tridip Soikia, your lordship.
Hmm?
Through phone, your lordship, IO has contacted Tridip Soikia. Serial number 19 is in reference to that. Now, if your lordship will see 21, your lordship, the checkbook that was received by the present alleged accused, your lordship, that is the checkbook from where the particular leaf was forged and the deposition was made, your lordship. And it was received by the present alleged accused.
Okay. So total 35 lakhs.
35 lakhs, yeah.
How many of them are in gold?
Two of them, your lordship. The one who in item number 6 who had withdrawn this week, this morning, your lordship.
What is his name?
Tidip Soikia.
Tidip. Okay, he's the main accused.
He's the main accused with regard to forgery is Kaushik Das, your lordship.
Okay.
There was a conspiracy for.
So there is a material against you.
Lordship, may I say one?
Yes.
Lordship, indeed, Lordship, the Tidip Saike is my friend, since we are belong from same place.
Hmm.
I have said it in my petition also, Lordship. On 31, the Tidip Saike came to Itanagar, and as a friend, Lordship, he visited my place, and I have also apprehended that during that time only he had stolen the safe. Moreover, Lordship, in
His bail application also, which is the item number, he has stated before this one, before that he will refund the amount also. He will refund the amount, he has stated before this court also. Dilip Sekhi has stated before this court also that he will refund the amount also. However, this morning he has withdrawn his claim.
Okay.
So I have not connected with this case. Just being a friend of the Dilip Sekhi, I have been implicated.
Hard,
Also, I am ready to,
okay, hard, Mr.
this extra.
And counsel for the petition. Also hard, Ms. Jenny, valid additional people, federal state staff. Apprehending his arrest from the petitioner. Kosik Das filed this bail application under section 438 of the Code of Criminal Procedure 1973 for granting pre-arrest bail in connection with TUPS case number 13/2024 under section 120B, 419, 420, 468, 471, 379, 34 of Indian Penal Code. Okay, I'll dictate, huh? Other submission.
Deeply.
So I'll return it.
Yes, sir. Deep.
This was 11, huh?
May it please, Your Lordship.
Yes.
Lordship, I'm on instructions, Lordship. Learned counsel for the respondent number 2, Mr. D. Sopi, is out of station today, Lordship, due to personal difficulties, Lordship. So kindly this matter may be posted on 24th, Lordship.
Okay. So well, during the course of the hearing on 8th or on 4th, a query had fallen from my lord as to whether the complainant has a locus standi to approach this honorable court under section 439 for cancellation of bail. Just place one. The honorable Supreme Court has said that apart from state, any aggrieved person and even a person from public can approach this honorable court under section 439. So, but today he's praying. The land advocate is out of station.
Yes, Lordship.
Where is coming back?
Lordship, he'll be coming back on 23rd, Lordship. So kindly this matter may be fixed on 24th, Lordship. He's on medical ground, Lordship.
Yes, where?
Lordship, kindly fix it on 23rd, Lordship.
23rd.
Yes, Lordship.
Is it okay? Mr. R.L. Kumar, non-counsel for the appellant. You are?
D. Lona, Lordship.
D. Lona.
On behalf of Mr. D. Lona, on behalf of Mr. D. Soki.
Mr. D. Lona, appearing on behalf of Mr. Dugesh Soki, non-counsel for the respondent. And Lakshmi also, huh? Also has
State Lordship.
an additional PP and Mr. D. Soki appearing on behalf of, sorry, Laura appearing on behalf of Mr. D. Soki, huh? Staff, huh? As grateful by the Lana Council for the respondent, Mr. Laura appearing on behalf of Mr. D. Soki, So, okay, learning counsel for the respondent. Please this matter on 23rd. Okay. Okay.
May it please.
Yes.
The last occasion, the matter was heard very extensively. And the order was passed that well endeavor will be taken to dispose of the matter today. The
This
other
matter?
side also appeared.
Okay. Okay, who is appearing on behalf of the, how many respondents are there? This is
23.
just a minute, this today is fixed for is order only.
But then the last occasion, the order was passed that endeavor will be taken to dispose of the matter.
To dispose of the matter.
My lord, because there is some urgency. Lordship may look at the order dated 27/3/2024.
27/3. Okay, so, all the parties are represented, respondents are present.
Yes, I am for a respondent, performer respondent number 3 to 23.
3 to
23.
23. And Mr. Tapopo?
1 and 2.
1 and 2. 1 and 2. Okay. So what is this matter?
Matter, my lord, your lordship will find.
State is also party here.
No, Your Lordship, I'll be assisting Mr. Tapo.
Okay. Okay.
Now, my lord, by filing this revision under Article 227, my lord, the petitioner has challenged the order passed on 21/3/2024. Now, your lordship will find it's a quite astonishing way the order was passed by both the courts below. Now, usually your lordship is aware, the plaintiff is required to prove his own case. And in this case, your lordship will find there is no finding given by the learned judge, both the trial judge and the appellate judge. They did not say anything how they have derived their satisfaction and whether the plaintiff has title in regard to the election which held on 4/10/2022 to be the lawful president and secretary in this particular case. There is no averment in their plaint. And even the learned judge also say, because of some loopholes on the part of the defendant, that is the only finding. I'll take your lordship to that. And that way, my lord, the injunction order was passed. And your lordship is well aware, while granting ex parte ad interim injunction, they must plaintiff, which is the duty on the part of the plaintiff, they will have to establish a strong prima facie case. Now here on the averment of the plaintiff, your lordship will find nothing. Rather, my lord, some averments are there which goes against them. Now your lordship may come down to the order dated, my lord, at page 44, I will take your lordship first. That starts from is the order dated 21/3/2024 by the appellate forum. This is the order
Page
in
44.
page, it starts from page 40, but then the operative, I mean, the judgment starts from page 44.
Okay.
Has the lordship got that?
This is judgment by civil judge.
Civil judge senior division.
This is appellate court.
Yes, appellate forum, my lord. The main order starts from page 40, 21/3/2024. Today case is fixed for order.
Yes.
Then your lordship may come to page 44.
Yes.
The instant appeal has been filed under section so and so. Your lordship may skip this part. Then para 2. The case of the appellant is that the instant appeal has been preferred to satisfy the order dated 4/3/2024
passed in miscellaneous case number so and so by learned civil judge, junior division, capital complex, for recall of ad interim temporary injunction order dated so and so, passed in miscellaneous case number so and so, was rejected and dismissed, and to set aside order dated 4/3/2024, passed in miscellaneous case number so and so, wherein the ad interim temporary injunction order dated 22/12/2023 was continued, and election result of the appellant dated 12/11/23 was stayed until further orders. Further, appellant along with respondent number 4-23 were restrained from functioning as state executives of PPA and also refrained from using the emblem, stamp and letterpad of People's Party of Arunachal Pradesh until further orders. It is averred therein that People's Party of Arunachal Pradesh is recognized political party registered with the Election Commission of India in August 1977. That appellant was elected as chairman of PPA on 22/12/2018, along with respondent number 1 and 2 as president and secretary of PPA for the session so and so. The next executive election was supposed to be held in the year 2021. However, no election was conducted as required under PPA constitution by the president for one reason or another. It is averred that respondent number 1 and 2 caused chaos amongst the members of PPA by claiming that post of chairman PPA was deleted by fourth constitution amendment of PPA. All members were against same, and none of the members were ready to accept said amendment. To restore party discipline in the capacity of chairman CWC, appellant issued circular dated so and so calling for holding of People's Assembly on 12/11/2023 as per resolution adopted by executive members. Same was published in the local newspaper, that is in Arunachal Times. Accordingly, People's Assembly was conducted on 12/11/2023 at Arunalaya, wherein the fourth amendment of the Constitution of PPA was declared as a nullity, as it was done with the following due procedures of law. On the same date, People's Assembly also elected new executive members for the session 23 to 2026 as the ground of excellency of time, since General Assembly election was likely to be conducted in the year 2024 and for proper functioning of the party. In the said election dated 12/11/2023, appellant along with respondent number 3 to 23 were elected as executive members of PPA. Respondent number 1 and 2 filed title suit before the Civil Judge Junior Division for declaring their rights over the title of PPA and sought a declaration that election result dated so and so be declared illegal, whereby appellant number 1 and respondent number 3 to 23 were elected as executive members of PPA and sought permanent injunction prohibiting appellant from terming their association as PPA and prohibiting them from using emblem, stamp and letterpad of PPA. Respondent number 1 and 2 also filed miscase number so and so in the said suit to stay election result dated 12/11/2023 under order 39(1) and 2 and the specific relief act. The learned court below passed ex parte ad interim injunction order dated 22/12/2023, wherein said result dated 12/11/23 was stayed until further orders. An appellant along with respondent number so and so were refrained from functioning as state executives of PPA, and they were restrained from using emblem so and so till further orders. Thereafter, appellant filed miscellaneous case number so and so under order 39 rule 4 for calling the ad interim injunction order dated 22/12/2023. However, prayer in this case was rejected by the learned civil judge junior division capital complex by order dated 4/3/2024. It is averred therein that grounds for instant appeal are that the learned court below heard in law as well as in facts in passing the MP in order dated so and so and the order dated so and so in title suit number 10 of 23 and same are liable to be set aside in quashed. That for grant of temporary injunction, there has to be a prima facie case in favor of the party seeking injunction, and there should also be balance of convenience and irreparable loss in their favor. Whereas there was no prima facie case since respondent number 1 and 2 were elected as president and secretary on 14/10/2022 without complying with Article 36D of Constitution of PPA. That respondent number 1 and 2 misled the court below by stating that there was 4th amendment to Constitution of PPA and post of chairman CWC was removed, and that executive members had authority to amend the Constitution, whereas executive members had nothing to do with the amendment. That Article 29 of the Constitution of PPA provides that Constitution can be amended only by People's Assembly, and 1 month notice. This is very important, my lord. You will also kindly have a reference to this. And 1 month notice is required to be given, but requirement of said provision were not complied. That there was no pleading to that effect, that election and 4th amendment of the Constitution of PPA was done by People's Assembly. On the other hand, no written reply. Now your lordship may skip that. Now, point for determination. Considering the ground set forth in the appeal memo, and upon hearing the learned counsel for all sides, the following point for determination is formulated. Whether the order dated 4/3/2024 passed in so-and-so, an order dated so-and-so is just and proper or needs interference. The learned senior counsel for the appellant so-and-so submitted that after the election of PPA held on 23/12/2018, appellant was elected as chairman, respondent number 1 was elected as president, and the appellant number 2 was elected as secretary of CWC of PPA, and their terms got expired on 22/12/2021. The election dated 14/10/2022, by virtue of which respondent number 1 and 2 are claiming to be president and secretary of CWC, was not conducted as per Constitution of PPA. Article 11(2) of PPA Constitution states that president shall be elected by People's Assembly for a period of 3 years, and Article 13(6) states that CWC shall be responsible for convening the People's Assembly. In the instant case, appellant being chairman, CWC did not convene any People's Assembly for said election dated 14/10/2022. And therefore said election dated 14/10/2022 is not legitimate and cannot be basis for granting of injunction order in their favor. That the 4th amendment of the Constitution of PPA, by which respondent number 1 and 2 illegally removed the post of chairman of CWC by passing resolution on 24/9/2023, was not as per due procedure, since Article 29 of Constitution of PPA requires that party constitution is to be amended by People's Assembly, and before that notice of 1 month is to be given. However, in instant case, no People's Assembly was held prior to 4th amendment on 24/9/2023, and neither 1 month's notice was given. He highlighted that in the copy of the said resolution annexed by respondent number 1 and 2 with their plaint and application before the lower court below, although name of respondent number 1 is there, but this signature is missing in the said document, which raises doubt on its authenticity. Further, he submitted that after issuing a notification, appellant held election on 12/11/2023, by which appellant was re-elected chairman of CWC along with pro forma defendants as its other members, and this election was stayed by the learned court below. On the other hand, learned counsel for the respondent number 1 and 2, Sri so-and-so, submitted that respondent number 1 and 2 did not mislead the lower court below, and both impugn orders of the lower court below are just and proper and needs no interference. He submitted that the result of election dated 12/11/2023 was rightly stated by the lower court below, since Article 38(1) of the Constitution of PPA states that President, in consultation with state executive, is to appoint a returning officer for conduction of election of the party. However, in the said election conducted on so-and-so, President, who is the respondent number 1, had not appointed any returning officer, and therefore the election dated 12/11/2023, by virtue of which appellant has claimed to be the chairman, is invalid. Further, he submitted that the said election dated 12/11/2023 was conducted by appellant by misguiding the party workers. That Election Commission of India, by its letter dated so-and-so had directed to conduct election. However, in the letter, the Election Commission of India addressed to PPA dated so-and-so, there is no direction to conduct any election. He highlighted that appellant had not challenged either the amendment or the election dated 14/10/2022 before the lower court below in their written statement, nor filed any counterclaim with their written statement in connection. I have heard both the parties, then Your Lordship, can we come to para 11. As this court is exercising the powers of appellate court, which are very limited in nature, I would like to reproduce the observation made by the Honorable Appeals Court, wherein the Honorable Court has laid parameters for interfering with the order of trial court in injunction petitions. In the said case, it was held, the appeals before the division bench were against the exercise of direction by the single bench. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitutes its discretion. Now, the learned court below missed this part, Your Lordship. This is very important, except, Your Lordship, mark this language, except where the discretion has been shown to have been exercised arbitrarily, capriciously, or perversely, or where the court had ignored the settled principle of law. My Lord, I will convince Your Lordship from the materials on record. This finding was given by both the trial court as well as the appellate court in a totally perverse manner, without, my Lord, scrutinize the case of the plaintiff. My Lord, they did a go-by to see what is the plaintiff's case, whether there is sufficient averment in the plaint. And now they are saying the trial court has exercised their discretion. So Supreme Court has said, well, in a discretion exercised by the court below, we cannot exercise any power. Then again, there is a rider, except the Supreme Court has said, where the discretion has been shown to have been exercised arbitrarily, capriciously, perversely, or where the court had ignored the settled principle of law. Settled principle of law means, my Lord, in a civil case, the plaintiff has to stand on their own legs. He cannot take weakness of the defendant. My Lord, the defendant may have some loopholes, but you cannot see the weakness of because you are coming up to establish your title first. You have to show the election which held on 4/10/2022. It was in terms of the constitution of the organization. You will have to first establish that because you have made a declaration, you have made a prayer in the plain that I am entitled to be a party holder in view of the election dated so and so. Now we will have to, your duty is you have to establish that first. Then Your Lordship may skip this. Then paragraph 12, my Lord, at page 50. This is also, my Lord, same, the Appeals Court is said in the similar manner. Their Lordship has also said, if there is a patent error on the face of the record, Your Lordship will find that. The para 12, my Lord, the Honorable Guwahati High Court in the reported case in so and so, while endorsing the ratio of Wonder Limited versus so and so Shupra, observed as, does an appeal against exercise of discretionary jurisdiction really an appeal in principle? And that is why, unlike a regular appeal, in ordinary sense, where whole evidence on record is examined, an appeal against exercise of discretionary jurisdiction is the legality and validity of the order, and it can be set aside and should be set aside only when there is a patent error on the face of the record or the order is against established settled principles of law. Now that, my Lord, I will establish how it is. Then para 13, thus to set aside or reverse the impugn orders as sought by the appellant, it must be shown that the trial court used its power in an arbitrary, capricious, and perverse manner. Then para 14, the relevant provision of law here is Order 39, Rule 4. That is, 4 means, my Lord, we have filed an application to vacate and set aside the order. Any order for an injunction may be discharged or varied or set aside by the court on application made thereto by any party dissatisfied with such order, provided that if in an application for temporary injunction or in any affidavit supporting such application, a party has knowingly made a false or misleading statement in relation to a material particular, and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless, for reasons to be recorded, it considered that it is not necessary to do so in the interest of justice. Provided further that where an order for injunction has been passed after giving to a party an opportunity of being heard, the order shall not be discharged, varied, or set aside on the application of that party except where such discharge, variation, or setting aside has been necessitated by a change in the circumstances, or unless the court is satisfied that the order has caused undue hardship to that party. Firstly, now the finding, my lord. Firstly, I am inclined to discuss the impugn order dated 4/3/2024. The relevant portion of the impugn order dated 4/3/2024 passed by the learned court below is reproduced below. In the present case, the defendants had sought vacation of the ex parte order dated so and so. The contention on behalf of the petitioner defendant is that plaintiffs had made false statement and misled this court that there has been Fourth Amendment to the Constitution of PPA, and the post of chairman CWC was removed. Plaintiff furnished copy of the resolution along with signature of the state executive. The order dated 24/10/2023 at Annexure 3 of the application also shows that the state executive did not deny that there was a resolution for amendment of the Constitution. Therefore, in my view, the opposite party's plaintiffs, now your lordship kindly see the finding, may not have followed the procedure provided under the Constitution for amendment of the Constitution. However, now when you are accepting the case of the plaintiff, they did not comply with the provision of the Constitution. Nonetheless, my lord, what the learned judge is saying, however, in contention of the petitioner cannot constitute evidence that plaintiff have made false statement. Now, when the particular provision here is 29, I'll take your lordship to that. Now, that provision, when you give a go-by, my lord, is the plaintiff case. You must establish that fact first. Now, there is no pleading that you have for the purpose of amendment. First, you need to make a people's assembly. That amendment is not in the plaint. Then before that, you must give a notice 1 month prior to that. That is also absent. Now, the learned trial judge is saying they might have ignored all those things. Nonetheless, what they say, however, the contention of the petitioner cannot constitute evidence, then plaintiff had made false statement. This court is of the opinion that there is no knowingly false or misleading statement made by the plaintiff. My lord, I could not understand what is the meaning of all these things. My lord, you are to see whether they have complied all these things. Now, knowingly or unknowingly, it's all the same. If you have not stated in the plaint, there is no such averment. That is end of the matter. Now, para 23, having considered under Order 39, Rule 4, in my view, the petitioner defendant has in the present case failed to establish, discharge the burden of proving that the plaintiff has knowingly made a false or misleading statement in relation to a material particular in either the plaint or in the interim application for temporary injunction. Therefore, the prayer of the petitioner is rejected. Now, this is completely perverse decision, my lord. I'll substantiate whatever I'm saying after taking to your lordship the relevant provision of the Constitution. Now, para 16. On perusal of the impugn order and case record, it is seen that the learned court below has relied on the resolution dated 24/2/2022 and the letter dated so and so. I have perused both the documents, although in first page of the resolution dated so and so, adjacent to the names of respondent number 1, Sri Kafa Bengia, and respondent number 2, Kaling Jarang, there are no signatures, but on next page dated so and so, there is signature of respondent number 2, so and so, so and so. In my opinion, absence of signature of respondent number 1 in the said resolution document cannot be said to nullify the entire document, considering it was signed by 18 members of executive body, office bearers of PP. Applying the provisions of first provision to Order 39, Rule 4 CPC, and the law laid down in a forced judgment to facts of the instant case, in my considered opinion, the decision of learned court below, stating that plaintiffs may not have followed procedure provided under the Constitution for amendment of the Constitution, but contention of the petitioner the plaintiff had made false statement cannot be accepted, cannot be said to have been exercised arbitrarily, capriciously, or perversely, or that the learned court below has ignored the settled principles of law. In view of the contents of aforesaid highlighted documents, said provision of law, therefore, in my considered opinion, the impugn order dated so and so is just and proper and needs no interference. Then I am inclined to discuss the impugn order dated 4/3/2024. Your Lordship may skip that, then Your Lordship kindly come to para 19. The opposite parties contend that the election was not held as per the Constitution, that as per Article 11(2), the President shall be elected by the People's Assembly for a period of 3 years. Further, in order to restore the party discipline in the capacity of Chairman CWC, the opposite party number 2 notified circular dated 4/11/23, calling for People's Assembly to be held on 12/11/2023. Now, Your Lordship, can you see they have started discussing about the defendant's case. People's Assembly meeting was conducted on 12/11/2023, attended by 301 members, including of executive members, and declared Fourth Amendment of the Constitution as nullity, and also elected new executive members for the session so and so. However, as per Article 38, 1A of the President, in consultation with the state executive, shall appoint a returning officer for the petitioner, plaintiff number 1, who is empowered to appoint the returning officer. Article 38F provides that the returning officer shall conduct election of the state president. Even assuming that the Fourth Amendment is illegal, and OP number 2 still holds the post of chairman, CWC, he is not empowered to appoint the returning officer. In the instant case, the defendant number 1 returning officer was appointed by defendant number 2. As per Article 36D, one of the functions of the People Assembly is to elect the state executive by secret ballot. However, an election conducted by returning officer not appointed as per Article 38 shall be considered illegal. From the aforesaid highlighted portion of the impugn order, it is seen that the learned court below has duly considered all contentions of both the parties in the application under Order 39, Rule 1 CPC, the case number so and so, and has referred to relevant articles of the Constitution of PPA, and thereafter come to the decision that although Fourth Amendment to Constitution of PPA made by respondent number 1 to another members of PPA executive body has not complied with the provision of Article 29 of the Constitution of PPA, which requires People Assembly to be held and 1 month prior notice, but same cannot, now Your Lordship, they have accepted it, now is turning around, but same cannot nullify the election held on 14/10/2022, which is conducted by duly appointing returning officer and by complying with the due procedures for conducting an election as required under Article 38 of the PPA Constitution. It is seen that the learned court below has further reason, on the other hand, that the election held on 12/11/2023, by which appellant was re-elected to chairman CWC, shall be considered illegal for violating the provision of Article 38 of the PPA Constitution, as appellant had no power to appoint any returning officer to conduct an election, even if assuming appellant was the chairman CWC of PPA. In my opinion, the aforesaid reasoning and decision made by the learned court does not show anywhere that trial court used reasoning and decision is based on provision of Article 38. Now, ultimately, my lord, it was rejected. Now, my lord, I will take your lordships to the plaint, which your lordship will find at page 74. My lord, I will take your lordship to the cause title first.
Just a minute. Just a minute.
74 minutes.
Just a minute.
The cause title reads like this.
Yes.
A suit under Section 9 of the Code of Civil Procedure, read with 3438 of Specific Relief Act, for a decree declaring the title in favor of the plaintiff. Now, what is that title, my lord? You want to say that by virtue of election which took place on 4/10/2022. They are the real party, and he is the president and secretary of the People's Party of Arunachal Pradesh. And that declaration to be passed. The prayer is, your lordship will find the prayer at page 90.
So, just a minute. So,
Rather, my lord, your lordship, it is better to see the contents also, whatever they have made. It is a short plaint, it will not take much time.
now prayer.
Before that, I'll draw your lordship attention in the statement made in the body of the petition at page 82 onwards. Because, my lord, at the stage of granting ad interim injunction, the learned court did not have any other material because the day one itself, the filing of the plaint, there is no evidence and all that. Only on the basis of the plaint, the ex parte order was passed. Therefore, my lord, responsibly cast much on the learned judge to see what averment has been made and whether it transfers any confidence on the mind of the judge that they could establish a prima facie case. In that exceptional, and your lordship is well aware, the ex parte ad interim injunction can be granted. It is not, there is no such reason that it cannot be granted. But it is in exceptional circumstances when it is really needed. Now, whether they could establish their case, to that effect, I am just drawing your lordship's attention. In page 82, the plaintiff's People's Party of Arunachal is a regional party of Arunachal Pradesh, and the party is registered with the Election Commission of India as required under section so and so. Your lordship may skip this para. Then page 83. The plaintiffs would like to bring into your kind notice that in the year 2019, the President and Secretary General of PPA was suspended from the party by the defendant number 2. Therefore, they filed a title suit before the learned civil judge, Junior Division, for permanent injunction. Then the para 3, the plaintiff most respectfully submits that the state executive meeting was held at the PPA office, Itanagar, dated 24/9/2022, where all the signatories like state executives, district president, women wing executives, state youth office bearers were present, and the House President has unanimously decided to adopt following resolutions such as Article 13 PPA Central Working Committee shall be discussed in detail by the party executives. The House unanimously decided to do away with the post of CWC chairman as it has been found redundant, regressive, and contradictory to the spirit of party politics. Then page 84, henceforth the party shall be headed by the president. The House also decided to fix the basic qualification needed for the post of the party president. It was decided that anybody wearing or the post of party president should have been an active members of the party. Now, your lordship may skip all other things. Then your lordship may come to page 85, para 5. That the plaintiff humbly submits that the election was held on 14/10/2022 and the results were decided on the same date. Sri so-and-so are unopposed as the president and Sri so-and-so was elected unopposed. That the plaintiff, then para 6, that the plaintiffs most respectfully beg to submit that on 4th November 2022, executive members has convened the People's Assembly and as per the Article 29 of PPA's Constitution made 4th Amendment of the Constitution as per resolution passed on 24/9/2022 and removed, amended the post of chairman and laid down 3 years active members eligibility criteria for holding the post in executive. Then para 7, the plaintiffs most respectfully beg to submit that the Secretariat of the Election Commission dated 36/2010 and 8/9/2010 asked for updated list of, your lordship, this your lordship may skip, it's not that much important. Then 87, paragraph 8. That the plaintiffs beg to submit that on dated 4/11/2023, the defendant number 2 issued a circular to convene a meeting by stating that the present office bearer's tenure has expired on such and such day, as per the Election Commission of India notified dated so and so. The same is also published in the Arunachal Times. Then, my lord, at page 88, para 10, plaintiffs begs to state that even after issuance of press notice dated 11/11/2023 by the plaintiff number 1, the meeting was conducted illegally and Sri Luiki Boje was appointed as returning officer and he was conducted the election illegally on so and so. Then para 11, that the plaintiffs would like to apprise the Honorable Court that as per the impugned election result of 12/11/2023, the defendants are declaring themselves as executive member of the party, thus usurping not only name of plaintiff's association, but its emblem, stamp, etc., etc. Then, my lord, your lordship, skip all this thing. Then kindly come to page 90, the prayer of the plaintiff. This is a very important prayer number 1 for declaring the plaintiff's right over the title of People's Party of Arunachal. They want to say, by virtue of the election dated 4/10/2022, the plaintiff is the rightful president and secretary, and they're the rightful parties of the People's Party of Arunachal. Now, my lord, since your pair is fast to make a declaration.
Right title or the title of the people.
People's Party of Arunachal. That means they want to say, we're the rightful person of the People's Party of Arunachal. Now, in that case, it is incumbent upon them and upon the learned court also to see that whether they have succeeded in establishing their case, saying that the election was held rightly on 4/10/2022. Now, in that regard, my lord, I will first say, now, my lord, I will take your lordships to the relevant provision of the Constitution. That is in second copy, no? My lord, your lordship may come to page 268. My lord. That is the Constitution. I'll take your lordships to 29. The left hand side, your lordship, mainly see. Article 29, left hand side top, my lord. Amendment.
Page
268, yes.
68. Okay.
The lordship got that.
20.
29, my lord. Article 29. In the extreme left.
Amendment.
The lordship found that.
Amendment.
Amendment, my lord.
Okay.
The party constitution shall be amended only by the People's Assembly. The notice or proposals for amending the constitution shall be given 1 month before the said assembly. My lord, your lordship will not find any sort of averment in the plaint in regard to this.
One month notice.
1 month notice is a mandatory, my lord. And the plaint is silent about all that. Now, my lord, if the constitution was amended, when it was amended, my lord, according to them, it was amended, my lord, their election was held on 4/10/2012. Sorry, 2022. The amendment according, assuming we are accepting their case, and the amendment was made later. If amendment was made later, on the day of election, my lord, every important decision taken by the House, approval of the chairman is a must. My lord, that your lordship will find at Article 13. My lord, page, your lordship, kindly look at page 265. That is Article 13, PPA Central Working Committee. 265. The lordship may come in the extreme left, Article 13. Yes. PPA Central Working Committee. Number 1, the PPA Central Working Committee shall consist of the chairman of the PPA, State Council, President, Secretary, so and so, so and so. Then straightway, lordship come to 5, number 5. The chairman CWC PPA shall be approving authority of all important decision of the party. Now, when the election was there on 4/10/2022, the chairman, the post of chairman was assuming their case to be accepted by the court also. The chairman was there on that date because the amendment was done later on 14/11/2022. Therefore, and that your lordship will find the amendment was done on latter part. I will take your lordships to page 166. No? मोटा है ना? No. Your lordship may kindly come to page 166. The order dated 22/12/2023. Now, the
166.
166 minute. This is the order dated 22/12/2023. The order passed by the Civil Judge Junior Division.
What order is this?
22/12/2023.
22/12.
Yes.
The order was passed in miscellaneous case.
Right. Now, the second part of the middle part, your lordship kindly see. The case of the petitioner plaintiff is that the plaintiff number 1 is the president of PPA. Plaintiff number 2 is the secretary general as per the election held and result declaration dated so and so. The defendant number 2 was the chairman of Central Working Committee. However, on 24/9/2022, the executive members of PPA convened a meeting and resolution was passed to remove the post of chairman. Filed for fourth amendment on 4/11/2022. Now, if it is correct also.
The basic challenge is against the removal of the chairman.
Removal, I mean the chairman, the post of the chairman was deleted from the constitution.
Without the information, without giving notice.
Without giving notice, 1 month notice, there is no people's assembly. And my lord, there is no averment in the plaint that they have complied with all that. Had it been in terms of the constitution, my lord, you can say that prima facie there is a case. Now, they have again total go by to all that. And the second part of my argument, this is the first part, my lord. The second part, my lord, if your election, you are saying it's a valid election on 14/10/2022. On that date, my lord, this post of chairman was not amended. I was there on that date. Now it was amended on 4/11/2022. If it is so, in that case, the election which held on 4/10/2022 should have been approved by the chairman in terms of the article my lord, 13.5, because Article 13.5 says, Chairman CWC PPA shall be a probing authority of all important decisions. Now, both the count, my lord, your lordship, and see, the plaintiff miserably failed to make up their case. Now, what happened in this case? They are saying the election which held by the PPA, this is our party, that is defective because the returning officer was appointed not by the president, because under the constitutional provision that has to be appointed by the president. Now, the president is not with us, he is doing anti-party activities. So therefore, People's Assembly has appointed returning officer. Now, assuming for the purpose of this case, my lord, the court is not required to see a defect in the defendant's case. First thing first, you have come up with some prayer for making a, giving a decree for giving a, my lord, say that you are the only party. Then what is your duty? You have to establish your case. Now, after discussing the finding of the learned, both the learned judges, the lordship will find, they have said, well, there may be some defect. Now, you are going to give a ex parte ad interim injunction, and you are saying that there may be some loopholes, there may be some defects. Nonetheless, you are coming not with discussing with, about their cases, you are coming up to say that defendant did not take these. Now, the Apex Court has already said, I'll place before your lordship, that you will have to stand on your own foot. You cannot stand on the loopholes of the defendants, because if the burden lies on you, if your lordship go to section 101, 102 of the Evidence Act, you must discharge your burden first. And what is the satisfaction of the learned judges? They are saying, well, the defendant did not do this, defendant did not do that. Now, where is the reflection in regard to our claim, that is 29, Article 29 have been violated? You did not give 1 month notice. The averment in the plaintiff is totally silent. Then, assuming that there is an amendment, the post of chairman has been deleted. Then, if it is correct also, when it was deleted, latter part of the election. Now, before that chairman was there, he did not take an approval. Then how it can be said to be it's invalid? The title which you're paying for, how can you get it? Now, your lordship, law is so clear. My lord, the Apex Court has said, if you, on the basis of the averment made in the plain and the prayer made in the plain, if ultimately no decree can be passed, you cannot pass any interim injunction also. Because ultimately, what will happen? If you fail in the decree, to getting a decree, and you get an interim injunction for nothing, then you are disrupting some legal right of the defendants. So those are the areas, my lord, I will take your lordships. Now, in short, my lord, these are my submission in. Now, what is the legal position? I will take your lordships. Then, my lord, in regard to this, it was resolution passed, the amendment was done 4/11/2022. Your lordship may see page 111 and 118 also. 111, my lord. Then the top, your lordship will find Constitution Drafting Committee. 111. Page 111. The amendment of PPA Constitution has been drafted by the 4th Constitution Amendment Committee of the People's Party of Arunachal after due endorsement by the People's Assembly held on 4/11/2022. Now, the amendment was done later on. Therefore, if they say that the election which held on 4/10/2022 without the endorsement of the chairman, that itself is an illegal election, and on the basis of that fair, they cannot get any decree. Then page 118, my lord. Article 14. Page 118 down below, your lordship, fine. Article 14, PPA Central Working Committee amended on 4th November 2022.
118.
118 minute. At the bottom, your lordship will find Article 14. EPA Central Working Committee
Yes.
amended on 4/11/2022. Now, as your lordship is well aware about the position of law, my lord. Now, if certain power is given to go in certain manner, one has to go in that manner, and, no, and otherwise not at all. No, that is well-marked decision. Decision मेरा judgment कहाँ रखा है? My lord, I will take your lordship to the decision of the Privy Council. It's a very old decision, my lord, that is uniform. That is by 1936 Privy Council, my lord, Nazir Ahmed versus King Emperor. Now, in that case, what happened, my lord? I think the time is matured. My lord. Lordship will rise.
So
At 2, my lord, because it's 1
Two.
o'clock. I will take another half an hour only.
okay.
I have some matter, my lord. because
Yes, yes,
after- At 2 o'clock also you can take up.
2.
Because my land in this matter will take some time.
आप कितना time लेंगे?
That's very.
But he may kill my time.
No, my lord, I'll take up to 5 minutes. my lord.
So who is the other for the other
At
side?
2 o'clock, my lord. Other people will be there. People, they are here.
Well,
They are-
subject to the condition, he will take just 5 minutes.
My lord.
Okay. At 2.
My lord.
God bless me. Question में आया कमा के फिर यहाँ कमाना है
custodial interrogation is sought. And my statement is recorded. Lordship, may kindly have a look at page 3, paragraph 12.
Yes.
There is no gainsaying that custodial interrogation is one of the effective modes of investigating into the alleged crime. It is equally true that just because custodial interrogation is not required, that by itself may also not be a ground to release an accused on anticipatory bail if the offences are of a serious nature. However, mere assertion on the part of the state, while opposing the plea for anticipatory bail that custodial interrogation is required, would not be sufficient. The state would have to show or indicate more than prima facie why custodial interrogation of the accused is required for the purpose of investigation. Now, merely because there is some pressure from other districts, here also I oppose and I say that custodial interrogation is necessary. IO has not said anything. And your Lordship will not go by what the IO is simply praying. His job is to pray and oppose everything. And right now, I am not in Alo. I am already transferred to some other place.
Okay. You're still in service?
Yes, still in service. I am about to retire now. In a month's time, possibly I'll retire. This is a case, it's an extreme case where persons who were working in the department as a contingency staff, they were regularized. There are hundreds of instances where persons who are working in a temporary capacity or casual, they are being subsequently appointed. Even by taking policy, the government sometimes regularizes. Now, this case. In respect of other districts, matter may be different. I do not know. So, for this district is concerned, this is the case. All were working as a contingency staff.
But since
it may be even assuming that this is irregular, proper procedure was not followed, because when they cancel this appointment, they said only proper procedure. Lordship can have a look at page 37. They have ultimately cancelled it, saying that proper procedure was not followed.
Since it was done at about the same time when this illegal appointment were done.
That is my difficulty. I am a victim of circumstance.
Yes. 37 order.
Yeah. These are all ultimately they were cancelled. First paragraph, it says, last line says, has been done without following proper procedure. So there are hundreds of actions are being taken in the department, by various departments where proper procedures are not followed. Will there be a fire in every case? And that too, they have added PC Act also. I have to go through the special judge, where the court is normally very strict in granting bail.
So,
absolutely no transaction, nothing. And there are difficulties in all other districts, allegations are totally different.
This seems a little bit different.
My lord, basically, to submit fairly, my lord. In fact, I've seen the document also, my lord. It says it is an irregular appointment. The procedure was not
irregular.
Normally, what happens, my lord, in the district, my lord, when the board is being constituted, it is done under the chairmanship of the deputy commissioner. But here is a case where, in an exigency, he has constituted board. I mean, there was a board, and it was sent to the director, and it was approved by the director. Obviously, there was a sanction post. It seems so, my lord.
And my lord, their requisition is already filed challenging the cancellation of this appointment also. Maybe tomorrow this court may pass an order in that way. And there is no allegation that I have taken money for doing this. Absolutely no allegation.
So this is for actually this report. I think this has been prepared generally considering the involvement in other cases.
No. Approval is taken from the
no. This status report.
Madam.
In respect of other district states, it may be proven.
Saying that while objecting bail, saying that custodial interrogation is also necessary, etc. So this is for other case probably.
Probably.
Since in the other case it is. Okay. So
as and when required, I'll cooperate. Lordship may kindly see the
with some additional condition.
humbly asked before, Lordship, the man is going to retire without any blemish in his entire service career. So condition only maybe that he will appear as and when required.
Mr. D. Majumdar, the senior counsel, assisted by
As Biswas.
the counsel for the petitioner, and Mr. Opada, standing counsel, SIC. By an order dated 28/2/2024, while calling for the case title, the accused applicant was granted interim anticipatory bail with the direction to release him on interim pre-arrest bail on furnishing of a bail bond of rupees 20,000. With certain conditions. Start. Mr. Opada, standing counsel SIC, produced the case status along with the status report, and I perused the same. Start. As per the report, when the accused appeared,
Appeared as 6th month.
7. After obtaining the interim anticipatory bail, the accused
7th March.
appeared before the IO of the case, IO SIC, on 7th March. So, on appearance, the IO has recorded, IO has examined and recorded his statement under 161 CRPC. As he stated in his 161 statement that it was about the appointment.
Yes, my lord, I have flagged it, my lord, that flag, the next page, my lord. It is very clear, my lord, in that.
Where is the appointment order? Have you annexed the appointment order?
Yes. That is all there. Page 23.
As per the record, the 9 MTS under the Deputy Director of School Education were appointed after.
Is it, they were working in continuous.
Okay. Records, all the 9 MTAs appointed, no? They were appointed or regularized, it was regularized or appointed?
Regularized.
Where do we find regularized? In the order?
Yes.
In the order,
The second line.
Okay,
Service
or
regularization.
lines were, taken up for regularization
After obtaining approval from the director.
after obtaining approval from the director,
And on the recommendation of the board.
director of school education and on the recommendation of
Selection board.
selection board of the district.
Right.
District. However,
These issues are subject of the recreational matter. So.
okay. However, after, however, during the course of investigation, or they were terminated?
No, before that. Before that. 2019 itself.
However, their regularizations were subsequently terminated.
They were done.
no, before.
After the inquiry. Yes, after the inquiry.
After inquiry, after conducting preliminary inquiry, I think, inquiry.
Yes, my lord, here, one correction, my lord. My lord, out of the 9, my lord, one of them, he was appointed on compassionate ground, my lord.
Okay.
Because he has donated the
9
land.
regularization, except one who was given appointment on compassionate ground.
Yes, he being the donator of the school ground.
Okay, being the landowner
father-
of the school.
Yes.
Okay, being the landowner of the
Yes,
school.
but he was appointed temporary as MTS, my lord.
Donor, okay. However, during the course of investigation, there are the services of all 9 MTS and
Cancelled.
10.
Regularization was cancelled.
Okay, the regularization of their regularization were cancelled. Stop. Look, one by one clarification he has given.
I've given an entire.
The learned counsel for the petitioner submits that the present case is different from the other district. And at the most, the action of the DDA, action of the present applicant can be termed as irregular. Irregular. Stop. The learned counsel for the learned standing counsel, SIC, clearly submitted that in the present case, as per the report, the appointment, sorry, the nine MTS were regularized. So 8 MTS were regularized and 1 was appointed on compassionate ground. So, and how, and there is no any money trail, but then there is a report.
Yes, my lord.
In a status report. So in respect of others, it appears.
My lord.
Has been found in the instant case and stuff. in view of the above, the and since the accused applicant has already appeared before the eye of the case and he has already been examined and his statement recorded under 161 CRPC. And the IO has also not indicated that his custodial interrogation is necessary. I'm of the view that the interim anticipatory bail granted to the accused on 28th to 2024 can be regularized. Accordingly, the interim anticipatory bail granted to the accused on 28th to 2024 is hereby regularized and made absolute with the same terms and the same condition with an additional condition that that condition was already there, that he will appear.
I don't know, against me, there is
That's the accused applicant shall appear before the IO of the case. So want him to appear in the week, something, in the day, particular day? No,
Nothing
not
like that,
required.
but
required.
as a when required
Okay.
by the investigation.
Okay. Say, the accused applicant shall cooperate and appear before the IO. Cooperate with the investigating agency and appear before him as and when called for. This bail terms condition will remain, that he will execute bail bond and etc. This will remain same. And then that if you will not induce etc. That condition is also there. I think that is that addition will do.
Yes, ma'am.
That much. Okay. With the above.
Induce or hamper or tamper with the evidences. Or
Hmm?
He will not induce.
That is there.
Or
That is
that-
already there. Okay. With the above, this bail application stand. But in the meantime, you can obtain regular bail from the.
That will create confusion, man. There is a second, and that one idea I find is creating
Is
confusion.
it?
Because normally your lordship is aware,
Ah,
the Supreme Court in the Rajesh Agarwal's case,
not required.
no, madam. Anticipatory bail.
That will stay. How long it will last then? Say for example, this is anticipatory bail. Till when?
Till the investigation is complete and charge sheet is submitted. After that, you will have to obtain regular bail from the.
Yeah, that is why I'm saying.
So that part need not be indicated in the Supreme
No.
Court where it says that.
Need not be indicated.
No, no, madam. Proximate kindness, para 91(1) of the judgment.
Otherwise, supposing if he doesn't surrender or if he is not been arrested in the
Yeah.
case.
Yeah.
So in the case, suppose in case he abscond, he doesn't appear before, then what the trial court will do?
Well, that is why the conditions are imposed, madam. If bail is granted, there is why condition that he should appear. There is no question of non-appearance.
So if he doesn't appear, say for example,
If he doesn't, they come up for cancellation of the bail. And the bailer will be arrested, who has given the assurance that he will produce.
because their forfeiture will not be there again.
Yes.
Because unless he appear or unless he execute a bail bond, here also he did not execute bail bond. Unless he execute bail bond, then the
That is what
forfeiture
I'm saying.
doesn't come.
That is why I'm saying, if he, my lord, Joshua kindness is one.
Hmm.
Once he grants, he's granted a bail order, he will be remaining on bail, but then he will be cooperating with the investigation. He will appear. If he doesn't do.
That is of course
That is
during the
why the
investigation
condition,
period. That is during the investigation period.
Yeah. And once charge sheet is submitted, then it is no longer required.
So,
Then we will obtain court bail.
okay. So to continue the,
Yes, till the charge sheet, because it is for the investigating agency to complete the investigation and submit the charge sheet. That is why the Supreme Court is saying, also the kindness of para 91(1). I will repeat for your also is aware.
Para 91.
Well, para 91(1). And bail bond will be submitted before the police. He has to appear.
Is there, Is there any page number also?
Page number.
No.
There are 91 1 minute towards the
Okay,
end. of
just a
the
minute.
page. There are 91 1.
Yes.
Regarding question number 1, this court holds that the protection granted to a person under section 438 CRPC should not invariably be limited to a fixed period. It should inure in favor of the accused without any restriction on time. Normal conditions under section 437(3), read with section 433(2) should be imposed if there are specific facts or features in regard to any offense. It is open for the court to impose any appropriate condition, including fixed nature of relief or is being tied to an event, etc. And then 91, 92.3 also in there. So, but that condition is, and he's a government employee, a local person, he's a government employee.
Because sometimes in the trial court, it's very difficult unless he execute the bail bond. You cancel the bail and the forfeit, whole bailer, because bailer also has not yet executed.
At the time of
But bailer has also not yet executed unless he surrendered himself and obtained bail.
this is not a case where.
Okay. It is another method.
And
Supposing if
offense
he
is always
surrenders,
clear. So he's an allegation against him has come only because
Okay.
there were irregularities in other cases.
with
other
the above
districts.
this bail application stands disposal. Okay.
I filed in fact, the director who is being granted bail by this on court.
This was, huh?
Well, this was the unvisited matrimonial.
Okay.
That's for clarification. Page 7 is the order, my lord. Proxy was pleased to pass an order on 1st of April 2024.
Page 7.
Page 7 it starts.
Yes.
Now, Proxy may kindly turn to page 12. Condition number 4, man.
This is which case? That is, okay. Page 7.
Page 7. Page
Condition
7
number?
starts. Page 7 starts. Man.
It is started page 7. Okay.
1/4/2024 order. Man. This is a 430 petition by Tapi Gau, who was the director in fact of the
Yes.
department in respect to the same FIR. Man.
Yes, yes.
Now, Lordship was pleased to grant the bail when the conditions are mentioned at page, my lord, 11 onwards.
Yes.
Now, page 12, Lordship has imposed one condition at serial number 4, my lord.
Yes.
Thereafter, a report to be made within 10 days from today. The accused shall appear or report before the IO of the case twice in a week, that is every Monday and Thursday at 10:30 a.m. for 4 weeks. And thereafter, Lordship can say, thereafter, once in a week, that is on every Monday at 10:30 a.m. for another 4 weeks. Then for the next month.
Yes.
And after that, as per the conditions to be imposed by the IO of the case, as per the requirement for further and proper investigation.
Yes.
So entire period your lordship is mentioned. I am not praying for any modification of that, my lord. Only thing is, my lord, the last page, my lord, serial number 12 possibly is creating some confusion.
Which one?
Next page, my lord.
Okay.
I'm just praying for a clarification, that is fine. That the petitioner shall apply for a grant of regular bail before the special judge within 30 days. And possibly my instruction is, your lordship.
30 days, of course, in the given circumstance. 30 days, supposing if he wants.
And possibly I do not know, I was not there, my friends were there. At the time of dictating the order, possibly your lordship did not dictate. Maybe some confusion that way, it is creating some confusion. Your lordship is otherwise covered the entire period.
Supposing, what is the problem? Say, for example, if he apply for the, say, charge sheet file, in the meantime, probably charge sheet will be filed.
And then if they do not file, then investigation goes on. Then what will happen? Lordship is already indicated in para 4, condition number 4. So it is covering the entire period. Again, if it is left to the special judge, it is creating a confusion. Possibly, I told you it was not.
This is the same which I have raised just now in the earlier case.
Yes.
So
some clarification lordship will make, because lordship has already said after for first month, second month, thereafter also how he should conduct, what is the condition imposed for being granted the anticipatory bail is already covered. And at the time of filing the charge sheet, when we will file our formal report.
So because these normally, now the situation with this, of course, say,
And I leave it to your lordship, lordship will give some clarification so that this doesn't be, because after 1 month, if he's following your.
this normally in the trial court, it happened that interim or anticipatory bail is there. Whether in this case, whether he has executed or not yet.
Not yet, because.
Not yet, not yet.
No, because of this confusion, man, otherwise he will execute.
So there was no confusion according to me, because this after execution, this after execution,
This para 12 will go.
that will go. But then in the meantime, supposing he filed regularization, the court will have no option but to grant him bail only, because since he is cooperating, he is appearing. The court, normally what we do in the trial court is we used to grant, since the High Court has granted, since he is under protection.
To be very frank, what your lordship is indicating, my lord, the client has got some apprehension, but what your lordship is indicating, they should not really grant.
Because thereafter, just the consider disposal. However, the petitioner shall be remain protected by this anticipatory bail till disposal of such regular bail application.
I'll leave it to your lordship. Some clarification may begin so that he doesn't have. He is an apprehension. Your lordship has granted the protection, but again, within 1 month, 2 more, if he submits and if it is rejected state, he will not have the benefit of the order of his partner. This is what he is apprehending.
This is anticipatory bail only.
My lord, that is there.
The situation might change also.
Yes, if it changes, then matter is different. But till it changes, he should get the benefit of what your lordship has given after a detailed order. And when the charge sheet is submitted, we will apply for a regular bail.
What kind of or how you want these to be clarified? Say after filing,
Lordship, possibly para 12, in my humble suggestion, para 12 is not necessary. When your lordship has covered the entire thing in para 4 very nicely, everything, first 4 weeks, second 4 weeks, thereafter also, your lordship is totally given the full guide. Para 4 is absolutely clear.
So what do you say?
I don't have any problem, my lord. I'm also a little bit confused with the para 12, my lord. As far as
because normally in the earlier, so even in the trial court also, if the person has obtained bail,
my lord,
during the investigation period, so he has been say after completion of the investigation, charge is submitted.
Then
the committal, after committal, then when he appear before the trial court, say session court, only the simple thing that is small one page that I may be allowed to continue on earlier bail.
If this is the understanding with all courts, my client will have no difficulty, but he has got some apprehension. Some courts are not acting in this manner, and he has got some apprehension.
My lord, my confusion is that, my lord,
what your lordship
30 days, my lord, whether we will be able to file this charge sheet on 30 days or not, my lord. Probably we should file it, but then I don't have any instruction as to when we will be filing the charge sheet, my lord. Therefore, since the investigation is going on, so we may not be able to file the charge sheet within 30 days. Then what happens, my lord?
No. Because the trial court is special judge only.
Yes, my lord.
So it is only directed to the trial to appear before the trial court to obtain regular bail, because the regular bail, this is only anticipatory bail. Regular bail, yes.
Lordship has granted anticipatory bail, which will continue till the investigation is over.
That is true.
After the investigation complete, charge sheet is submitted, then I have to obtain regular court bail from the court. Thereafter, this order will not help me anymore. But till then, it should help me, man. That's what I'm saying. Now,
so that way it can be corrected.
Well, that way, yes.
That way.
Well, some claim from your lordship side, that will be enough.
Okay. Okay. Mr. D. Mazumdar, Senior Counsel, assisted by Mr.
As resource.
Okay. Direct counsel for the applicant. I've also heard Mr. Opada, Learned SC, SIC. Start. By filing this application, the applicant seek modification, waiver of condition number 12 of the order dated 1/4/2024, passed in AB number 42/2024. Within bracket, Sri Tapigao versus State of AP, bracket follows. The Adjournment Council for the applicant submits that since the condition 1 to 11 covers the entire period till the end of the investigation. The condition number 12. What have you stated there about that? The imposition of condition on number 12 to obtain to apply for grant of regular bail before the Special Judge BC Act within 30 days would create confusion. You said that in these 30 days, the investigation may not be able to complete.
May not be able to complete, and in the.
It's not necessary, of course. So, is within 30 days, the IO of the case may not be able to submit charge sheet, complete the investigation and submit charge sheet. Stop.
By clarification, doctor may say that as soon as the charge sheet is submitted, we'll apply for regularity.
Okay.
By the clarification.
In view of the above submission, the condition number 12. Just a minute. The condition number 12, stating that condition number 12 that the petitioner shall apply for grant of regular bail before the special judge PC Act within 30 days from the date of state order shall stand corrected as yes within inverted comma that the petitioner shall obtain regular bail from the special judge after submission of the charge sheet. Okay. After submission of obtain a bail from the special judge PC Act after submission of the charge sheet.
That will do.
Okay. Start. The order dated 21.
1/4.
Mr.
1/4.
Stands corrected as above. Stand corrected as above. These orders have to that extent, huh? Stand corrected to the extent as indicated above. So, with the above. These orders shall read along with the? Yeah. Okay, bail, because bail order dated 1/4. 1/4/2024. With the above, this IS stands disposed of. Okay.
No, item 22 to 32.
22?
Same order.
Oh, same order.
Yes, 22 to
Okay,
32.
I'll correct the last part, huh?
Okay.
Okay. Same, huh? अभी क्या ही होगा?
22 to 32, same.
From here. And this?
I will like.
Oh, still here. 32. Okay. Yes. Yeah. So this matter has not yet been admitted. Can you do that, admit and fix for hearing by fixing date? Because they'll, I'll have to hear both, and then judgment is to be kept as CAB. I have some more CAB. Can it be fixed for admission? Or admission hearing, or admit or fix it for hearing?
It can be today's this for orders only. This matter needs to be admitted then heard. It will take time, definitely. It will definitely take some time.
No, that is why I'm saying.
It can be admitted and
Next week, no, that is why I'm saying. So immediately on 13, immediately after this week, in the holiday, I have to leave.
Next week.
So I have few CAB. Then the last week.
Let's do one thing. Next week, छुट्टी कब है? Calendar, do you have calendar?
After election, this matter.
This old matter, it appears. Is this matter connected with the election?
Definitely. Because party tickets have already been issued to
Now,
candidates.
I think, all those things are over.
Yes, it will have a ramification on entire election process.
That's not the thing. Thing is this, my lord.
Right.
Whether the injunction order.
That is true. That is true. I could understand.
Whether these are tenable at all. These are rank illegality in both the order.
Right.
So therefore, my lord, whether we are not.
That is why I'm
connected
saying it can be admitted and can be.
No, my lord, admission is not required.
Not
to be
required.
admitted.
So for admission hearing.
Keep it open and fix a date on. कब करेगा? Vacation कितना पे गए? 22 next ना? Well, आज कितना तारीख है?
It can be on 23 or 22nd.
18th तक बंद है ना? 22nd, can it be on 22nd, Malu?
Okay.
For my lord, on that date, the entire matter may be disposed.
Right. We'll fix for orders or for admission hearing, we'll say.
Yes.
Admission hearing.
Admission hearing.
Okay.
And both the parties have agreed that on that date, the matter can be taken.
That
up
can
and
be, that
discussed.
can be done because in the very beginning, it was shown urgency. So that is what that can be done.
And my lord, so far my argument is concerned, essentially I have more or less completed.
Right.
We have to furnish certain Supreme Court decisions on. Those I will take half an hour, but then my learned friend may take also some time.
He may also take some time. And
It's so voluminous. Definitely.
The matter is only voluminous, but point of law is very short.
Right.
Therefore, we.
But then
should
you
not
have to
be-
cover. You have to cover.
Yes, yes.
That is why.
My lord, we should not be succumbed by the volume of the brief.
Right.
This is point
course.
is very small.
Right. Point is small.
Yes.
But then while covering.
Yeah, because
the
since the
judgment
lordship
again
is
have to
not there
cover
in
it
the
all.
next week, to keep it parted is a big problem.
Yeah, that is big problem and
In
then
the process,
don't want to keep.
we also forget, your lordship will also forget.
Yes, yes, that is
Then we
right.
shall have to refresh
That is
our
right.
memory. So it's better to be taken up on 22nd, no?
22nd.
23rd. Monday it will be very busy. Monday busy order. All busy order. Court will have all 23rd will be better.
All right, my lord.
Because for his time, for your time only. Because otherwise Monday so many cases will be listed. It might be difficult to finish up the matter. That's why. Tuesday is a better day.
Okay. Mr. S. Datta, Lana Senior Advocate, Senior Counsel, as he said by.
Also, Your Honor, in the cause list, it has been reflected as Surajit Datta, it's Sushil Datta, so that change may be made. Registry may be directed to change the name of the senior counsel.
Oh, okay.
My name has been shown, my lord, Surajit Datta, but it should have been Shishir Datta.
S. Datta. So this is okay. Surajit is.
It has
some
wrongly
other
been-
counsel. It is
Okay.
wrongly shown, Surajit.
S. Datta. This is Surajit. And then
Shishir Datta.
Shishir, okay. Shishir Datta, Lana Senior Counsel, as he said by. Yes. Bhutia. Lana Counsel for the petitioner. I've also heard Mr. P. Tafo. Lana Counsel for
Petitioner, respondent 1 and 2.
the respondent number 1 and 2, and Mr. Lana Counsel for the respondent number 3 to 23.
Except 6. 6 I'm not preparing.
Okay, who is 6?
6 I'm not preparing.
Okay. 6 is also private respondent.
Yes.
Except 6, huh? Then, 3, 4, 3, 4, 5, and 7 to 23. Huh. As prayed for, as agreed upon by both the Lana Council for the parties, and as shown an urgency in the matter, this matter is fixed on 23rd.
Well, only my request will be, if it can be kept in the list as a top of the list.
Okay, 23 April. To be listed in the top of the, but then at least, 20 April for admission hearing. The matter may be listed on the top of the admission hearing, no?
Yes. And both the parties agreed to, my lord. so
Absolutely
that-
agreed, as agreed upon by the parties and as urgency being shown.
And the entire matter may be disposed of.
So we don't know if service would be complete in case of respondent 6 or not.
No, 6, the service is complete.
I
It
don't
did
know.
not appear, that's the.
Completed.
Service is
6.
complete.
I think service is complete.
We have
Okay,
filed
then
our,
here in the first sentence, since all the parties have, are represented, Okay. On which the last, on which date and endeavor shall be made to dispose of the entire matter. Okay.
Much obliged.
Hmm.
My lord. May I, my lord?
13 हाँ ये हो गया और ये वही था ना 12 and 13 okay 14 yes
My lord, this IA is filed to implead the party, necessary party. Sri Panida Kalita is respondent. And
in what case
criminal petition number 21723.
criminal petition
Yes. In
criminal
respect to
petition is for
criminal,
what
quashing of
question
charge sheet.
okay so the person to be impleaded is a victim
Yeah, yes.
okay.
Respondent number 2, as respondent number 2. Your Honor, my lord may peruse the page number 8. This is the order dated 27 to 24. 27 to 24 by this honorable court.
What?
To implead the party, necessary party, by way of filing an interlocutory application.
Okay. Heard, Mr.
Tempahi.
Learning counsel for the applicant. And also Miss Jeannie, you are appearing. Okay, Miss Jeannie, learned additional people for the state of Arunachal Pradesh staff. By filing this application, the applicant prays for impleadment of what is the name of the person to be impleaded?
Sri Panidar Kalita, complainant. Panidar Kalita.
Okay, Sri. It's PHA, Panidar.
Yes.
Panidar Kalita, son of Habiram Kalita, residence of. Who is this?
He is the uncle of.
No, he is informant.
Yes, informant.
He is the person who lodged complaint.
Yes.
Okay.
No.
As per charge sheet, please charge.
No, he's not the complainant.
He is not the complainant, not the informant. Then either victim or the informant. What case is this?
This is
POXO, not POXO.
No.
Victim or what? Who?
He is the complainant.
No,
As per charge sheet.
Main petition.
Must be informant or the family. Who is he? Have you
He is
stated
complainant. As per police charge sheet, he is the complainant.
He is the
charge sheet,
complainant?
Yes.
What have you stated? Where have you stated? Pray for implement of the informant Sri Panidar Kolita. Is respondent number 2 in. What is the main case number?
21723.
In
criminal petition number 217.
Criminal
petition number 217.
Petition number 217. Criminal petition number 217/2023.
Your Lordship, if take up the main petition, Your Lordship, because the complainant here is shown is different. The FIR is Nayan Jyoti Burman.
Okay.
Yes, my lord. Actually, the FIR was lodged by driver of the vehicle who was
Who is
driving.
this? Who is this? Panidar?
But police has made the complainant the uncle of the victim. Yes.
Uncle of the deceased.
Yes.
Okay. Panidar, huh?
Yes.
So impede the complainant, Panidar Kalita, who is the uncle of the deceased victim, within bracket deceased, huh? Okay. No objection, I think.
No, Your Lordship,
Uh-huh.
if he could at least show where
Yes,
Kalita is, because I'm finding it hard. Oh, yes, Your Lordship, charge sheet is,
Is there?
it's there.
Okay. Ms. Jenny Lana additional PP has no objection. Stop. In view of the above, the prayer for impleadment of Sri Panidar Kalita complainant, a respondent number 2 is allowed. So this, it can be corrected in the post title or need to file one
Your Lordship,
amended post title.
normally he ought to have filed an amended course title, Your
You
Lordship.
file amended course title. Okay, accordingly, the petitioner shall file amended course title in criminal petition number 217/2023. Stop. The registry shall do the needful for. Thereafter, the registry shall do the needful. Stop. With the above, this IA stands allowed and disposed of. Okay.
My lord, the notice may, sir.
Main case is also there.
In item number 15.
The,
No,
in the main case, it will pass.
main case, Your Lordship, on
Main
filing,
case is listed today.
yes,
there?
Your Lordship,
Okay.
item number
In the
15.
main case, huh?
Once the amendment,
Okay. In view of the order passing IA CR L 23 AP 2024. Impleading Sri Panidar, what is his name?
Panidar Kalita.
Complainant as the respondent number 2. The petitioner shall take steps upon the newly impleaded respondent number 2 by a registered post with AD within how many days? 4 days from today. 4 weeks after. List this matter after 4 weeks. Okay.
Number 16.
This is in 14, let's say 14 and 15. Okay. 16 is unlisted. Okay. Yes.
My lord, I have filed an anticipatory bail application.
Okay.
The petition, however, case was registered against me. I will name the accused.
Your name accused?
Yes, my name is there in the file.
Okay. What is the offense involved?
Offense, so this is election related offense. Maybe I read this from page number 11. And wait for me.
Okay.
The subject urgent finding of FIR for severe assault under section 325 of IPC, causing damage to the accused under section 425 of IPC, criminal intimidations and issuing threats to life under section 307 of IPC. Respected sir, with regard to above cited subject, we are writing to bring to your immediate attention as distressing incident that occurred on the evening of 29/3/2024 around 11:30 p.m., which demand urgent actions from your esteemed department. A group of approximately 200 thugs and goons wearing masks, armed with deadly weapons of Chow Jignu Nabdul, led by individuals named Sri Chow Anisa Manchay, Sri Chow Peng Mamang, Chow Sihana Chotang, Chow Chenkun Mansai, Chow Tenkham Manchay, and Chow Miling Hankyo, and others, engaged in severe assault under section 325 of IPC, causing damage to our vehicles under section
425 of IPC, criminal intimidation and issuing threats to life under section 307 of IPC against our workers of Sri Likha Saya and NCP candidates near Power Grid in Manmau. Upon approaching Manmau, around 200 goons of Sri Chao Jignu Nabjos, led by the aforementioned individuals, brutally attacked our team of NCP, causing severe injuries to Sri Sayo Isak on his head and backside of his body, and also loosened his teeth. Sri Likha Dadar has also received head and body injuries, and also to Sri Takam Tada. They also totally damaged two gypsy bearing registration number AR01L 9453 and AS07B7495, and both are still missing. Further, they snatched the phone of Sri Isak before this, having inserted mobile number this Takam Tadan Poco, X3 having inserted mobile number this, Lika Tajar Oppo having inserted mobile number this. On fighting the uncontrolled and proud, harboring malicious intent and fearing the safety of life, we tried to run away from the spot. Yet again, they steal us and attain us and attack us with the intent to kill. All these incidents were within the knowledge of the Superintendent of Police Council, since he provided us security and took us to the police station. He further took the medical examination of us and also took our statement. The assailants, armed with eventually harboring malicious intent, intercepted our vehicles and subjected our party workers to brutal assault, resulting in severe injuries and extensive damage to our vehicle, while also instilling fear through explicit threats. Such act of violence and corruption are utterly intolerable. Therefore, I urgently request the registration of an FIR against the named perpetrator as well as any other involved in this reprehensible act. Additionally, I implore you to launch a thorough investigation to promptly apprehend these criminals and ensure the justice is served. The people of Namsai place their trust in our department, in your department, to uphold justice and ensure the safety of all law-abiding citizens. Your swift attention and action in this matter imperative to restore faith in our legal system. Thank you. Regard consideration and anticipated cooperation in this matter. Here, Your Honor, though they had names, because they themselves say that there were around 200 persons who were present at that particular point of time. And the named persons here, they are the active workers of the Bharatiya Janata Party who is supporting the opposite candidate. So they intentionally makes their name, basically highlighting their name so that they cannot take part in the election procedures. Moreover, if that is the case, if SP was there, why they have not instantly registered a case and they have not annexed the medical report also? So they alleged that the offense was committed at 11:30 hours, but the case was registered only on 1620 hours, after more than 15 hours. But they have not annexed any medical report to support their claim that they have actually sustained any damage or photographs of the vehicle which was damaged. This is a mere allegation against another political party.
On the same day it was received and registered, they appeared.
Yes. 33 was filed, launched. But LA offense was committed on 29/3 around 11:30 p.m. 11:30 p.m. So the offense
So
was
11:30 p.m. on 29th. So in the next morning, immediately
they should have filed it in the morning, but instead of that, they had filed in the evening without annexing the support.
that could be understood because normally for the person to write even FIR also,
Yes.
they take time.
It takes
So it's
time.
on the same day and in the process, on the same day it was registered. That is fair enough. So
Here, except all the allegations are valuable offense except section 395. Dacoity.
and they have also at least 307 also.
307, but
No,
in
Your
FIR
Lordship,
it is not.
only in FIR, but registered,
In complaint only.
Okay, no, not in the register.
not in
In the 325, 395.
395.
395 is there. So all issue notice.
Your Lordship, Your Lordship call for the CD, Your Lordship. This is an AB. AB, your lordship may call for the CD fixing it. AB.
Will be considered.
Interim, Your Honor. I'm praying for interim. I will appear before the IO and I will give my statement. I will cooperate with that.
So,
Your lordship, my only submission before your lordship is that there is an allegation of 200 goons at that point of time, your lordship. That has to be looked at. Otherwise, your lordship, if your lordship fix this matter after election, they would be deprived of their rights, your lordship. And therefore, I pray that this matter be fixed on 12th. Meanwhile, we'll bring the CD, your lordship. 12th.
okay.
Because
On 12, the interim will be considered.
yes, your lordship. Because because otherwise, your lordship, when there is an allegation of 200 goons, your lordship, only some of them has name has been reflected, your lordship. Even in these names, your lordship, the AB, there are one person whose name has not been reflected, your lordship. The rest of the two person has not come before this, your lordship, before this court, your lordship.
Okay.
And to reveal the name of other accusers, your lordship, that has to be found out, your lordship. A very short date on 12th, your lordship. Interim may be considered on that.
Pardon, Mr. T.K. Deori. Planning council for the applicant. I've also heard Ms. Ginny, Lanet additional PP, AP. Papa. So each one has filed separate application.
Separate.
Yes, I have filed separate, all the, on the same.
Para. Apprehending his arrest. Where has it stated that you apprehend the arrest? So the police has done anything thereafter? Or issued notice, etc.?
No.
So since only there is, you are named after.
Yes, my name is
Okay.
there, so I am apprehending.
Apprehending his
Para number
arrest
5.
in connection with commission of the non-bailable offense. And in connection with Namsai PS case number 26, 2024, registered under section 325, 395, 427, 506 of the Indian Penal Code. From the petitioner filed this application under section 438 of the Code of Criminal Procedure, seeking ground to pre-arrest bail. Issue notice, returnable work rules, call for the scan copy of
CD.
The additional PP shall produce. The shall also produce the status report of the above PS case on the next date, which is fixed on
12th for
12/4.
yes, your lordship.
Okay, start. Okay, 12.
Deeply.
The interim prayer shall, on which date the interim prayer shall be considered. Okay.
Deeply.
It's the same.
Same order in 16, 17, 18, 19, 20, and 21. Hardly, she has. You have. Okay, that's fine.